All right, good morning. So I think it's working now. Go take the roll, please, Sasha.
Commissioner Adaro.
Here.
Commissioner Cardenas. Commissioner Hatch.
Here.
Commissioner Hayward. Here. Chair Remke.
Here. Thank you. Good morning. I just want to take a moment to welcome our new Commissioner, Frank Cardenas. He comes to us with 25 years of government service, private consulting, and practicing law. He does have a special interest in business ethics and corporate governance. He most recently has been an adjunct instructor at the California State University in Los Angeles. And we're excited to have him, and I think that both his private and public service is going to serve us well. So thank you. Welcome. Okay, so is there any public comment for a matter not on the agenda today?
Chair Remke?
Yes.
So I have two, possibly only one. I understand that we're taking matter 3 off the agenda. Is that right?
Yes. I was going to talk about that after I gave the public an opportunity to see if there was any public comment, but okay, go on.
But the reason I ask is because if we're taking it off and we're not going to be able to discuss matter 3, then I would like to discuss it during public comment as a public. Or we can put it on the agenda just for discussion and no action. I don't know if we can do that. Mr. Woodside, I don't know how best to handle this.
Well, it is an enforcement matter, and so I would be cautious about discussing it if it's not officially presented to the commission on issues that may ultimately come before the commission. I mean, I'm not sure. Perhaps Ms. West can bring us up to speed as to why it's being pulled, and maybe that will answer your questions and or give you an opportunity. So let's just go with number 3 for right now.
Sure.
Okay. Galena West, Chief of Enforcement. So as you can see, this is a default for $60,000 for someone that is still currently in office and has reached out to us that wants to become current on his filings. And as disclosure is our goal, we've decided to work with him. And so he's working with the legal division to come up to date with his filings, and we wanted to give him some more time to do that.
That's kind of what I figured, which is a good sign.
Mm-hmm.
I don't know what ultimately is going to be. I imagine that it's going to be presented to us as some kind of a stipulation if you reach an agreement. And so I wanted to, and I don't know if this is the appropriate time to discuss some thoughts that I had about it, because I don't know if this is the appropriate time, or we wait until it comes back as a stipulation. But I don't know if you want our guidance as you go through your next round of negotiations with him, or you would rather wait, or would be more appropriate, and Mr. Woodside, maybe you can weigh in on, whether we just wait and it comes back as a stipulation and then we either approve or don't approve.
Jack Woodside, General Counsel. I think that's the best way to proceed, since it has been pulled as a discussion item, and you can always give direction when it comes back before the commission.
Okay, that's fine. That's that on number 3. And then my second public comment was only to express my thanks to the legal department, and specifically Mr. Fieser, because thanks to the work that was done by the legal division and some research that was done, I was able to swear in my son as a lawyer because I sit as commissioner, and that was a big surprise for me, and he did it all through working with you. So I just wanted to tell you I appreciate it. It was an unbelievable experience to swear in your own son. So thank you.
Okay, so was there any public comment for an item not on the agenda? Okay, seeing or hearing none, we will move on to the, well, first of all, just to make that clear, items number 3, 22, and 23 are being pulled from the agenda, so they will not be heard today. So moving to the consent, the remaining items are 4 through 21. Do the commissioners have any items they would like to take off consent?
Point of order, should we approve the minutes?
Yes, we should. Is that next? Sure is. Okay, so sorry, I skipped item 2, the minutes. Any corrections or comments from the commissioner on the minutes?
I move approval.
Commissioner Adaro,
I'm just going to abstain because I wasn't here.
Commissioner Cardenas,
I was not here.
Commissioner
I
Hatch,
believe I abstain. I abstain.
Aye.
Commissioner Hayward,
Aye.
Chair Remke.
Yes.
Motion passes.
Okay, thank you. All right, now moving to the remaining items on the consent calendar. Right. 4 through 21, and Commissioner Odero, I saw you had some you wanted pulled.
Right, I need to pull 4, but only because I am going to have to recuse myself on that.
Okay, so we'll pull 4. Any other items pulled from the consent calendar?
Pull any, but I have 3 questions on 3 of them.
Okay, so we'll get to those in a minute, but hearing no other polls. So Commissioner Hatch, why don't you start with your questions? Go one at a time, please.
Okay. Item 4.
Well, okay, so if you're going to go
Oh,
item
I'm sorry,
4.
that's been pulled, so I'll let it go.
Yeah, let that one go. We'll take that separately.
All right. Item 5. This was presented as 2 counts, and in my tortured mind, it seemed like it should have been appropriately 4 counts. My logic is here that you had 2 broad categories, late filed and just not filed. And within each of those, you had contributions made and other contributions received. And late contributions, you've heard the diatribe about how I feel about that. It seems like they get minimalized by ganging them all together, and this is, to me, it could easily be 4 counts. So I'd like to get your view, Galena, on this.
Certainly. Galena West, Chief of Enforcement. As you can see by the breakdown, what we tried to do is find a reasonable method. And this was also negotiated before the comments at the last meeting were taken into consideration. But as for the ones received, if you look at count 1, it would only have had a $4,000 amount received in its count by itself. And then in count 2, that would have been the $1,000 contribution. And so since those amounts were so small, we took them in aggravation instead of as separate counts, because otherwise the fine amount would be much larger in order to justify 4 counts for the $1,000, which meets the threshold exactly, and then the $1,500 and the $2,500.
Yeah, you don't dispute that there's different kinds of activity made versus received. It's just you felt that they were small enough.
Right, and since the law is all the 24-hour reporting for made and received at the same threshold, we have done a couple of cases in the past where we have combined them as well.
Okay, thank you.
Any other questions on item 5? Okay. Commissioner Hatch, you had another?
Yeah. Item 16. This is streamlined, so it shouldn't be too complicated here. But in this item, it was the only item that proposed, I think it was $400, and the direct comparable was item 19, which was $200 for the very same thing. And I was wondering why this particular one was $400. It's streamlined, so it should be kind of cookie cutter.
It is streamlined, and it is cookie cutter, which is exactly the procedure that we follow from the May 2015 memo. So basically, the memo states that if we have cooperation and filing with the first contact to where we have cooperation completely and somebody made a mistake and they're filing late and they get the $200 fine. And if they don't cooperate and we have to do a lot more effort and contact them more and get them to file, then the fine has gone up.
Yeah, it was a little hard to see that in what's in the document, this STIP. So there's a different level of cooperation, is that what you're saying?
Yeah, and in fact, this would be a second level of cooperation. So if it had gone to probable cause report and then on to accusation, then the fine also would have elevated by 200 each time.
Okay, thank you.
Were those all your questions, Commissioner Hatch?
Yes, thank you.
Any other questions from the commissioners on the remaining items on consent?
I have a question on item 23.
Okay, item 23. Oops,
No,
that's not consent.
no. Skip me, I wrote the wrong thing down.
Do you want a minute?
Yeah, let's see if anyone else has questions.
Any other questions from the commissioners? Okay, well, while you're looking, I'll go ahead. Any public comment on the remaining items on consent 5 through 21? Seeing or hearing none. Commissioner Hayward, let me know when you're ready, if you want to skip or
Actually, it was 23, and
it's pulled. So.
yes, it's pulled, so never mind.
Okay, is there a motion for the consent calendar?
I'll move approval of the consent calendar items 5 through 21.
Second.
Commissioner Adaro,
Yes.
Commissioner Cardenas,
Yes.
Commissioner Hatch,
Aye.
Commissioner Hayward,
Aye.
Chair Remke.
Yes.
Motion passes.
Okay, so we'll go back to item 4, and Commissioner Odero, you are, are you recusing yourself? Do you state on the record her reason for recusal?
Yes, reason for recusal.
So my reason for recusal is that I represent the ACLU of Southern California in a multitude of cases, and this involves them as a contributor as well, I think as a contributor as well as a sponsor of the committee.
Thank you. Okay, so you'll step out, and we'll
And with that, I'm out.
yeah. You want to just?
You want me to come back?
We probably won't be that long, but okay. We'll talk slow. So item 4, any questions from the commissioners as to item 4?
Madam Chair, I had a question.
Okay, Commissioner Hayward?
Or maybe it's just concern, or I cut to the chase. I think the negotiated fine here is very low for the conduct at issue. I think we're looking at a respondent that is sophisticated, a campaign that is of great public salience, lots of attention being paid, and failure to file contributions that I think they probably failed to file. I shouldn't cast aspersions on their motivations, but the monetary contribution in the amount of $500,000 that they received on the 15th has got to be something that they expected before the election, and I wonder about the calculation of the timing, because knowing and having reason to know versus just waiting and getting the check later. They still have a bank account, and they still have money in the bank, so I don't feel like we're chasing someone into bankruptcy if we ask them to pay a higher fine. The professional treasurer, I would think, would have known better. And so that's pretty much it. I think they're really getting away with not having to pay much of a fine for violations that I think are pretty significant.
Hi, Glenn West again. A lot of information went into this case. As you can see, it's much older. It was I believe, a 2011-2012 audit. And so by the time that we opened the case, it was January of 2016. So while it does seem low, they signed a tolling agreement for us to even have a lot of the charges that we have now, which is a great level of cooperation. And they were remedying for current behavior for the 2016 election at the same time. So we did give that great weight in order to come to a stipulated agreement. And also, when we were looking at the contributions themselves being non-monetary contributions of an ongoing nature, which was the majority of what was beyond the $500,000 contribution, then we were taking that in consideration as it was ongoing personal services that were being donated to the committee as non-monetary contributions. So we also took that in consideration, that it was the sponsor that was giving the non-monetary contribution. And since that was known, since it was the sponsor of the committee, we thought that that lessened the harm as well. And then as to the $500,000 contribution coming on the date of the election, it is a very troublesome issue that we do run into quite a lot. But having been in an FTB audit and they thoroughly vetted the issue themselves and then we looked at it ourselves, there was no way for us to prove that this came in before the election or they knew about it. We do run into this generally with accrued expenses as well, where a mailer goes out as an accrued expense and the printer just miraculously gets paid after the election with no contributions being attributed to the committee before the election. So it is an ongoing problem that we are trying to find a solution for, but as of right now, this is, the legal definition was it was reported after the election, and that's when it was required.
Okay. Any other questions from you? Any other questions from the commissioners on item 4?
Yes,
Commissioner Hatch?
thank you. I was a little bit puzzled on this in-kind contribution of staff. This is pretty much an ongoing basis. Do we have a standard that says how often you have to report that, or is it just whenever they feel like they're going to wrap it up?
It's notice and knowledge. So when you have notice of the contribution, you report it within 48 hours, but it's also when you have knowledge of the contribution.
But it's every day for, in this case, right through the election, correct?
Right, and if it's the amount of volunteers to where it's $1,000 every day, you can cumulatively cause yourself to have to file reports. But for a lot of non-monetary contributions, they are bulked together when it comes to sponsor committees providing services. And like I said earlier, that was one of the things that we took into consideration when determining the fine amount.
Okay, so every time it accumulates to a value of $1,000 worth of in-kind contributions, that triggers an obligation to like report that segment. So like if it's a total of $50,000, it should have been 5 reports, more or less.
If it comes to $1,000, then you can group some when you're estimating and then come back if you're 20% off. So you have that for non-monetary contributions.
They didn't report this till after the election, as I recall, right? It was a big
Correct.
number.
Correct. $60,000, I think.
So they didn't provide those interim reports?
Right. I believe that it was a few that were due within the last 16 days. The non-monetary contributions were $81,000 and the monetary were $29,000 for count 1. And the ones that were due, sorry, I'm getting used to glasses. And the ones that were due before the election attributed to a small amount that weren't reported. So all in count 2 were reported before the election, but not all in count 1 were reported before the election.
That is it, maybe I've got my facts mixed up, but I thought that one of those in-kind staff time, ongoing staff time, was reported the day after the election, and it was pretty sizable.
Mm-hmm. Right. The count 1 information was not before the election, but the count 2 information was.
So just for my frame of reference, I wanted to get an idea of what should they have done. So not just that they should have reported a day or so earlier, but they actually should have broken this up and reported it incrementally, you think?
Right, so when your staff time is donated, then you would report it incrementally, correct?
So they, either actual or an estimated, they need to report it every time it's an increment of $1,000 worth of in-kind services, correct?
More or less, yes.
If there's a nuance it's escaping me, I'd like to know what that is, so.
It's just the estimation nuance. So if you get a report from the donor and the donor says, I gave a $2,500 non-monetary contribution of staff time to you, you report that. But if you're estimating how much staff time that you received, then you can bulk that.
Right, but I mean, if I complied by giving you a report of $5,000 worth, and then I, give you another one for $7,000, what happened to that obligation to do it every $1,000? Is that?
Well, you would do it at the 7,000 because that's when you got notice. So that's why I'm saying it's a little complicated. So what the treasurer here was saying was that she didn't receive notice of that timely, and that she received the non-monetary contributions, but she didn't receive the exact number until later. And so one of the things out of the multitude of 81,000 that she didn't do was estimate it and file the report on the estimated amount. So that's
They were the
why
sponsor
this one's a
of the
little
committee,
complicated.
correct? Didn't she say that?
Yeah, they're responsible for filing that.
Yeah, it seemed like it should have been earlier. Okay, thank you.
I would just add that when I first read this, I tend to agree with some of the concerns raised by Commissioner Hayward as to the ultimate amount of the fine when you look at the size of the committee and the $8 million raised and spent. But just because I think there could be a possibly better stipulation being stronger, I also do take into consideration the real concerns about our ability to prosecute this case based on the timeliness of it. So when all's said and done, I do think it's a fair and reasonable settlement and a good job on a complex case between you and FTB. So I do appreciate that.
I would add that there was one further wrinkle that the law changed at that time between election cycle reports and LCRs. So this is when the 16 days changed to the 90 days for all reports. And so this committee was also tangled in that law change.
That period.
Right, because that law change went into effect January 1st, 2013.
Question.
Commissioner?
I'm sorry, what's an LCR?
I'm sorry. I do that.
Oh, I'm sorry.
Sorry about that. So right now we call things 24-hour reports because well, I guess not new, 2013 law is that anytime you get $1,000 made or received to your committee, you file a 24-hour report. And so we call them generically 24-hour reports, whether it's made or received or about an independent expenditure.
Within 90 days of the election.
Within 90 days of the election, and it includes the election date. Before that, the law was bifurcated to where there was different rules for electronic filers, there's different rules for primarily formed filers, and there was a 16-day before the election of 24-hour filing for everybody that was called the LCR period, the Late Contribution Report period.
Late contribution report.
Right. Sorry.
Follow up on that.
Commissioner Hatch?
Thank you. One of the items, I don't remember which one, didn't refer to them as late contribution reports. It said $5,000 reports. Is there a difference, or is that just somebody's terminology?
No, that's a great point. In the electronic filing portions of the act, they also came up with a $5,000 report. So if you're outside the 90-day cycle, then anytime it's $5,000 instead of $1,000, you're required to file a report within 10 days.
Oh, 10 days. So it's a 10-day report. Okay, thank you.
Okay, any public comment on item 4? Seeing or hearing none, is there a motion?
I will move approval.
Second?
Second.
Commissioner Cardenas?
Yes.
Commissioner Hatch?
Aye.
Commissioner Hayward?
I wish we'd gotten this sooner. Aye.
Chair Remke?
Yes.
Motion passes.
Okay, so is Phil getting Commissioner O'Darrow? Thank you, Ms. West. threw off telling her it wasn't going to be long, and then it was long. Yeah, no. Okay, so we are on item 24, the proposed amendments to Regulation 18535. Mr. Norton?
Good morning, Chair Remke and Commissioners. I'm Zachary Norton, Senior Counsel, Legal Division. Today, staff is proposing, at the direction of the Commission, amendments to Regulation 18535. And I'll note that these are the same amendments that were proposed at last month's meeting. Regulation 18535 was originally adopted to provide clarification regarding the limits on intercandidate transfers. At its July meeting, the Commission discussed the intercandidate transfer limit, which at that time applied to state candidates who are the subject of a recall election. The Commission subsequently adopted an opinion, as well as amendments to Regulation 18535, permitting unlimited contributions from a state candidate to another state candidate who is the subject of a recall. During deliberation of these regulatory amendments, a comment letter was received asking the Commission to consider reversing its longstanding interpretation that limited one state candidate's contributions to another state candidate's legal defense fund and candidate-controlled ballot measure committee. Although the Commission could not take action on this proposal at that time, it did direct staff to prepare an amendment incorporating these changes. Staff has prepared an amendment to Regulation 18535 as requested, which would explicitly permit unlimited contributions from a state candidate to another state candidate's legal defense fund and candidate-controlled ballot measure committee.
So any questions from the commissioners for Mr. Norton? Okay, is there,
comment.
oh, Commissioner Hatch?
This was before us last month. We were short. There was only 3 members. I think the law is very clear. These should be adopted. The Supreme Court ruled on the ballot measure committee issue, and this is long overdue. Thank you.
Any other comments from the commissioners?
Questions?
Okay, Commissioner?
Do I need to introduce myself for the record? I mean, every time? No? All right. Is it Mr. Norton?
Yes.
Mr. Norton, in what other contexts may a state candidate committee receive contributions which are unlimited?
Because of recent changes, the unlimited contributions may be received in the context of a recall election. And the changes that we have proposed today would just sort of extend or remove those limits for these 2 other situations.
That's the only time, that's the only occasion, I gather this has been decided, but for Johnny come lately here, that's the only time that a state candidate committee may receive contributions from anybody which are unlimited. That's correct?
Yes, that'd be correct.
I'm not sure. Do you have Commissioner Hayward, did you want to add something to that?
Well, isn't it the case that a candidate can give himself unlimited money?
Oh, yes.
But other than the
that
candidate.
is true. Other than the candidate, this is the only time where one candidate may contribute to another candidate. It's in these currently for the recall election, and this would extend to these 2 other situations, the Legal Defense Fund and the Candidate-Controlled Ballot Measure Committee.
So the only candidate-controlled entities which are not, because of the recent change to the inter-candidate transfer of monies, the only entities to which a state candidate is now precluded from accepting money from another state candidate is his legal defense fund or their controlled ballot committee. These are the two exceptions which the commission has directed you to suggest to us should be changed.
Yes, yes, it would just be for these two.
In addition to the recall.
In addition to the recall, which we've already permitted this.
So the notion that it's state candidate to state candidate on their general election committee, right? Limits apply. We carved out the exception for the recall, and now we're looking at 2 additional exceptions for the limits to these 2 committees as well.
All right. Well, hopefully this is the only time that the new guy exposes his ignorance. but I have-
No, it's been a complicated issue, so
I have
don't
my
worry.
doubts, and I make no
Yes.
promises about that. But is there any limitation on the type of underlying grievance or charge? The reason for which a state candidate would require legal defense at all? Is there any prescription? Well, you know, if it's serial murder, no, we're not going to. For example, in corporate law, we have the context of ultra-virus. If it is outside of the realm of the individual's, performance of their duties.
Yes, I see where you're going on that, and there are other limitations specifically as to what committee funds may be used for, and those types of defenses, it would have to relate to conduct that relates to the office holder, so it'd have to have something to do with wrongdoing by the committee. Murder accusation, that would criminal,
Right.
something that's not related to holding office, that would not be permissible. So this does not open the floodgates for legal defense for anything and everything. It would actually be something like the enforcement actions or some kind of investigation or administrative action that is resulting from acts or omissions by the candidate or committee.
So can I just jump in? So this does not impact the law or restrictions on legal defense funds at all. So that law as it stands now and the restrictions on what it can be used for connected with the state candidate remain the same. The only issue is how much money can go in there from another state candidate. That's the only issue before us now. So if there are restrictions, those restrictions are not touched by this proposal.
That is correct.
And my question is, are there restrictions? And I gather the answer is yes.
Yes,
And those restrictions are within or without the Political Reform Act?
those are contained within the act, yes.
okay.
And then those are
In other words,
separate.
Commissioner, read the act.
No, I'm trying to hope someone's going to jump forward with the exact language of what it says it has to be for, but I guess we'll follow up with you on that. It is in there and it does provide some guidance, but of course it is an issue for interpretation from time to time and a request for advice we receive from time to time whether or not a certain expense is allowed under those restrictions.
Yes.
Any further questions? Okay. Any further questions from the commissioners? Okay. Any public comment on item 24?
Good morning, Madam Chair, members of the Commission. Richard Rios from Olson, Hagel, and Fishburne. Welcome, Commissioner Cardenas. With respect to this issue, I just request that the Commission adopt the regulation. To address Commissioner Cardenas's question, the candidates who have a ballot measure committee are permitted to accept unlimited contributions from any source other than other state candidates. And so this adoption of this regulation would allow state candidates also to contribute unlimited funds to candidates' ballot measure committee and legal defense funds. That's all, Madam Chair, if there are no questions. Thank you.
Okay, thank you. Any other public comment on this matter? Seeing or hearing none, is there a motion?
I move for adoption.
Second.
Commissioner Darrow,
Yes.
Commissioner Cardenas,
Yes.
Commissioner Hatch,
Aye.
Commissioner Hayward,
Aye.
Chair Rumkey.
No.
This motion passes.
Okay, item 25. Thank you, Zach. Okay, these are proposed amendments to regulations affected by AB 249, the Disclose Act.
Yes. Good morning, Chair Remke and Commissioner Suki Barra, Senior Counsel with the Legal Division. I'm here today to present 8 regulations in light of the passage of AB 249. These are regulations that needed to be amended due to the passage of that bill. This is the second phase of regulations. The first phase of 9 regulations was adopted by the Commission in December. So with that, staff recommends approval of the proposed amendments on the agenda today.
Okay, questions from the commissioners as to the proposed amendments? Commissioner O'Darrow?
Aye, thank you. Thanks for putting all of this together. I know it was a lot of work. I have a question about 18401.
Okay. Go ahead.
Bring it up and, because I'm going to point you to a specific.
Okay.
So 18401 creates a record-keeping requirement.
Correct.
And help me out here, because I can't find that anywhere in AB 249.
Which record?
The record-keeping requirement that was added to 18401.
About the earmarking and the record keeping of that?
So, little I. Okay, hold on. 18401A 2 little 2I. It's probably not the best way to.
The 2 little I's?
Yeah. So a committee making contributions with earmarked funds must maintain documentation showing which earmarked funds were contributed to another committee.
Correct. So AB 249 requires a committee to provide information to another committee when they're giving earmarked funds to that committee. So that's where this comes from. It's requiring record keeping for that transaction that is required by A2, which, passing that documentation is required by AB 249. So this is requiring records for that.
I agree that AB 249 requires passing information from one committee to the other as a top contributor, and there are rules about that. I get that. What I'm asking you is, where in AB 249 is a record-keeping requirement?
It doesn't specifically have a record-keeping requirement, but from the requirement in the bill that talks about a committee is required to keep to provide documentation to the next committee, that's where we're getting this from.
So it appears to me then that we're creating a record-keeping requirement that AB 249 doesn't have. Out of whole cloth, I might add.
I don't see it that way, but that could be one interpretation of it, yeah. I believe we do have authority for it with the bill.
So I guess that's my question, is where is our authority to create a record-keeping requirement?
So we have a section in the Act that has record-keeping requirements in it. That would be section...
May I, while we're looking for a specific section or citation, it would just occur to me almost a priori that this would be kind of a necessary and proper administrative enablement. In order to enable the enforcement of the Act, there needs to be, how would one know if there were not records which were maintained by somebody?
Right, and so these records help us make sure that the committee is in compliance with the requirements of the Act. If they don't have records of it, it's very hard to make sure that they have done that.
But isn't that...
Excuse me?
Well, it was interrupted in the middle of my conversation. So I'm just going to continue.
Once you're recognized, thank you. Commissioner O'Darrow?
So my question is, if it's it seems to me that when enforcement goes in, it would be up to the committee to show whatever records it has in order to defend itself,
Correct.
right? So it sounds like we're trying to find a way to create a record-keeping requirement that is a defense already for the committee. And my concern is we're creating something new that doesn't exist within AB 249, and the only thing we're doing here is we're amending regulations to implement AB 249. So I'm trying to find where AB 249 allows us to do that. That's number one. And number two, I guess my question would be, so what happens if they violate this new record-keeping requirement?
Okay, so record-keeping requirements are provided for in the Act in Section 84104. And what that section says is that it should be the duty of each candidate, treasurer, principal officer, and elected officer to maintain detailed accounts, records, bills, receipts necessary to prepare their campaign statements. So it's staff's
So it's
belief
already
that
there.
it falls within that, yeah.
So if it's already there, why do we need to create a special record-keeping requirement within this regulation?
So we created that record-keeping requirement because we received comments from interested persons that they would like that written specifically in the regulation, and we believe it's necessary for guidance to people who want to comply with the law.
So what exactly was said at the interested persons meeting about this?
That they would like, I can't remember if it was at the meeting or comments received later, but it was basically that they would like there to be a record of this transaction.
But there is a record of the transaction.
Well, they would like there to be a requirement to keep a record of it.
Okay, so let's unpack all of this because a lot was said. So number one, it didn't or did not happen during the interested persons meeting.
I said I could not remember if it happened during the meeting or a comment I received after the meeting, but it came from an interested person.
And did that comment come in by phone? Did it come in writing? Can we see it? You tell us
it
what the
was
comment was.
It was between me and Trent Lang from Clean Money Campaign. So, and I believe he is here. So maybe he recalls when we talked about it, but it was talked about.
Well, okay, so we can get to that. So the question again, and I apologize if you answered it, but I didn't quite capture the answer. What happens if this particular record-keeping requirement is violated?
It could be a potential violation if there's no record of it.
So now we've created a law, in essence, by regulation, that creates another potential violation for a committee that didn't exist in AB 249.
Not specifically in AB 249, but it's part of the act.
But if it's part of the act, it's already there. I guess my concern is we're using the passage of AB 249 and we are creating regulations that are supposed to facilitate the implementation, clarify the law, facilitate the implementation of the act. And here, I believe we're creating something new for which there could be a violation. So let me ask you, if there's a violation of that, what's the penalty?
It would be the same as any other violation.
So it's $5,000.
Right.
And how would that work in terms of $5,000 per what?
Per violation. I mean, that's up to the discretion of enforcement, but just like any other violation that we see on the agenda, there are negotiated settlements, but it would be the max of $5,000 per violation.
No, I understand, but what would the violation look like? Would it be one time for each person who was a top contributor, if that information wasn't recorded in some ledger somewhere? Would it be for every top contributor? Would it be one violation per campaign? What does that look like?
So every time that a campaign committee did not keep a record of that transaction, that would be, in my opinion, a violation.
Okay, so it's per transaction, like per top contributor person.
Every time the money is passed.
Okay. Okay, so, and then what do you mean by documentation? What exactly is enforcement going to be looking for?
They look for copies of checks, any type of bank statement. Sometimes campaign committees can create their own record of it.
So,
Those types of things.
okay, thank you. So the concern I have is, I think that as a committee treasurer, I guess, you now have this new record-keeping requirement that I think is also, on top of it, vague, because I don't know what it means to maintain documentation for this. So I have a concern about that. And then I don't know if anybody else wants to address any of that, because I have another question, but it's unrelated to the record keeping.
If you wouldn't mind, while you're on that particular point.
Go ahead.
Commissioner Hatch?
You had mentioned that we have a general requirement that exists now for record keeping, but apparently it's not very detailed either, is it?
Yeah, it's not as detailed as what Commissioner Adair
Right,
was
it doesn't
talking
have individual categories of kinds of infractions. So to the extent that we want to be more specific, would we not notice and revise that regulation, that existing regulation?
Correct, we could do that.
Could do that. And then the other thing that is concerning to me as I hear this unfold is that, in effect, we're sort of highlighting this one infraction as like special. So then are we going to be obliged to go back throughout our regulations and highlight in context all of these other kinds of infractions relating to record keeping?
No, we don't have to do that.
Don't have to, but it seems like we're then making this one sort of special, and it kind of, and then you have to wonder, well, why is it special?
Can I just, I mean, is everyone, we're all clear, right, that 18401 is an existing regulation which does exactly what you're talking about for the generic requirement in the Act. So the Act is generic. Maintain records. You're required to do that.
Right, in a broad way with no detail about
Right,
what
and then
type,
we have-
what constitutes a record.
Right. And then we have 18401 in place now, which is an existing requirement, required record keeping. That's already the existing regulation, which breaks it down in a much more detailed way to provide more information to guide people and not hopefully set them up for an unknowing violation. And then, so what we're doing with this proposal is adding the details of this particular disclosure to those existing regulations.
I don't see detail there. What I see is a reference to the record keeping related to this issue. And what it smacks of is making this sort of an extra special violation, and I don't know where that leads in the future. That's why I think it's perhaps misplaced. If you need to clarify the general requirement that's already in regulation, that would seem to be the place to do it. But I tend to agree that it shouldn't just be piggybacked on here as a special,
So I'm clear, are you proposing that the record-keeping requirements for the Disclose Act be in a separate regulation? Is that your
No,
suggestion?
I'm not. I'm saying that the existing general requirement for record keeping be modified as need be to make it clear relative to some new categories. And this seems to, without providing the sufficient detail as to what it relates to, is sort of elevating this one a little bit above every other record-keeping requirement, and it's misplaced. And you have to find it. Now, if I were wanting to know what are my record-keeping requirements, I'd go to the general section of record-keeping. I think if I comply with that, I'm good. But now we got this one planted over here someplace that I have to find, and that's the kind of things that gets people inadvertently in trouble.
But that's the point, it's in the general record-keeping requirement. So if I want to know my record-keeping requirements under the Act for campaign statements, I go to 18401. That's where all this, and it's pretty detailed. The accounts and records must contain a continuous computation of campaign account balance. I mean, it goes on and on for those under $25, those under $100, over $100. I mean, it breaks it out in detail what is required under the broad category of the act. So I'm just trying to get clear. You say it should be in here or it should be in a separate place?
Should be there.
Okay.
So it is. This is the record-keeping regulation. This is the general regulation where everyone goes to find out what records they have to keep.
For campaign statements?
Yeah.
And all the duties under Chapter 4 of the Campaign Statement Act. Do other commissioners have questions regarding 18401 while we're on it?
I have more.
Right, I'm going to get to those. Okay. Just want to kind of hit this one.
18401.
Oh. Do you want to continue on 18?
I get your point on that. Thank you.
Okay. Commissioner Odero has further questions on 18401.
Yes, thank you. So on 18401, well, wherever it is exactly, but the reference to the first in, last out reporting,
Yes, that's in the little I.
yeah, yes.
Can you say
thank
where it is again?
It's on page 2 of the proposed amendment, and it is found in on line 15. It starts that paragraph. It's in there.
Thank you.
So the rule in AB 249 says reasonable accounting method to figure out who you're going to disclose, right, as the top contributor in certain circumstances where it's not clear if you're contributing more than the earmarked funds that you received, or if you received both earmarked funds and non-earmarked funds and you contribute. And the suggestion is made, I suspect, among others, first in, last out. No, last in, first out, which I interpret to actually mean last in, first disclosed. Is that what you mean?
Last in,
First to be disclosed?
what this is talking about is, so the last earmarked correct, yes, I get what you're saying.
Okay.
Yeah.
Okay. So I have questions about that because I'm not sure that last in, first out works. So I want to give you a couple of hypotheticals, and I want you to explain how your reasoning that last in, first disclosed gets disclosed.
Okay.
So, okay, on day one, you have $50,000 from donor A,
Okay.
which is earmarked for Measure X. Day two, you have $100,000 from donor B, also earmarked for Measure X. And on day three, you have $50,000 from donor C that is not earmarked. All of these would be considered top contributors, right, because they're $50,000 and above.
Mm-hmm.
So this committee receives $200,000, right? But it contributes $150,000.
Okay.
How is this reported? How is this disclosed, I should say? Under the last in, first out method.
Okay, so sorry, I'm trying to
It's okay.
reference everything.
I get it. I had to think about it myself and kind of come up with this, so I understand you. Take your time.
Would you like a lifeline?
Sure, go ahead.
I'm just wondering if Trish wants to help, who is the campaign statement, filing
Yeah.
expert? If Trish, you want to assist in some of these more detailed accounting methods and questions as you handle those every day and provide the advice. Yes, this is putting you on the spot, so go.
Hi, I'm Trish Mayer, Assistant Chief in the Legal Division. And if I understand your question correctly, because the contributions from A and B were earmarked, those would be the first two used. And then once those are used up, you'd go to the non-earmarked funds.
So that's not last in, first out.
Last and first out with respect to funds that were earmarked.
So what would you report here?
What would,
What would you disclose in this hypothetical?
as far as the record keeping or the actual reporting?
No, the actual disclosure,
On the ad.
using the reasonable accounting methods to figure out which contribution to report.
Contributions from A and B.
And that's because they're both earmarked. And so we don't look at the one from C because it's not earmarked.
Correct.
Okay, I'm not sure that's what last in, first out says, but okay. Now, okay, I have another one. So that was one situation, right, where you receive earmarked funds and non-earmarked funds.
Okay.
And when you bring it all together, you've received X number, and then the committee is contributing less than that, right? So that takes care of the one circumstance where you have to, excuse me, figure out who to disclose. So let's look at the other one, where you receive more earmarked funds than you contribute to another committee. So day one, you receive from donor A $75,000. Day two, and they're all earmarked, and let's say they're all earmarked for the same thing, okay? Day two, you receive $100,000 earmarked from donor B. Day three, you receive $50,000 earmarked from donor C, and day four, you receive $50,000 from donor D, for a total of 275,000 receipts.
Everything's earmarked.
Everything's earmarked for the same purpose. And then the committee contributes $175,000. Who do you disclose?
So then that would be the last in, first out. So you would disclose the most recent one, moving backward from there.
So what happens, so that's 100,000, right? Donor D and donor C are 100,000 together. But you have to disclose 175,000. So do you just disclose, the donor 2, the next one, right, was 100,000. What do you disclose there?
So you would disclose the rest from them,
75.
75.
And that would leave 25,000 donated from this donor that, well, wouldn't make him a top contributor. Well, so what happens to that 25,000?
So if they don't use it and it's still there, it depends on what the committee uses that 25,000 for. They may use it for ad, they may not. They may give it to another committee.
If they give it to another committee, because originally this person was $100,000, which would have made him a top contributor, is this person then listed as for 25,000 as a top contributor?
So if it's given to another committee and only 25 is given, then they're not a top contributor for that new committee on the ad because they didn't give the 50,000 for that ad.
Okay. So I question the last in, first out as an example. I guess it's an example of a reasonable accounting method. What consideration have you given to other reasonable accounting methods, and what were they?
This is the one that we've been using in other circumstances. When it comes to multi-purpose organizations, this is what we've been using. So that's why we decided to use it again here, because it has been thought about in the past And so we went with that one as the example.
Okay. I just wonder if do we anticipate problems? I mean, why not just let people do their own, and I guess you are letting people do their own thing, pick their own reasonable accounting method. You're not going to require last in, first out.
Right, and an original draft of this had a requirement of last in, first out, and we changed it to have it as an example, to give guidance if people want it, but it still has this reasonable accounting method language there, too.
Okay. Okay. Thank you.
Would that override, though, the reasonable accounting method?
So if somebody uses the last in, first out reasonable accounting method, then we're going to say that's not a violation because it's actually an example we provide. Is that your question? It helps people, it gives guidance to people who want a direct answer on how to do it.
Well, but if you put this in, is it sort of a de facto requirement that you do it that way as opposed to other ways?
It's not a de facto requirement, but it's, I think, more of like a safe harbor. If you use it, you know, you can be sure that this is okay. That's why we provided an example.
So example is a little short of a safe harbor, but just...
It doesn't mean that they have to use that method.
Commissioner O'Darrow?
So how would you feel about changing this to say, this determination must be done using a reasonable accounting method such as, and then here, comma, without limitation, comma, the last in, first out accounting method?
That is fine with me.
Any other questions on 18401? Okay, do the commissioners have other questions regarding other regulations?
Yes.
Commissioner Hatch?
Clean Money had suggested adding some language to 18450.1A1.
Wait, which reg?
18450.1A3.
Is that one on here this time?
No, that's not up right now. It's up at the next meeting.
It's not in this package?
No.
Oh, I apologize.
Just to clarify, there was an interested persons meeting on Tuesday regarding that reg. That's the sign regulation that has the interplay with the Disclose Act. And so I think the Clean Money Campaign submitted a letter in response to that IP meeting.
Right.
But that's not on this agenda.
Numerically, it was within the range of stuff we were doing. So I thought
Right.
it wasn't.
But that will be coming back.
The timing's confusing, but that's coming back next month.
All right, thank you.
Okay. Any other questions on the remaining regs?
I just have a procedural question.
Commissioner O'Darrow?
As we vote for this, are we voting one by one or are we voting in bulk?
It could be a motion made. It depends on how you want to make the motion. Okay. No other questions? Oh, sorry.
For whomever, my question relates to, I guess it's Section 85704, earmarked funds, the definition of earmarked funds.
Sorry, are you referring to the statute itself? What did you say?
I believe it's the statute itself, Section 84501.
Okay, thank you.
The definition of earmarked funds. The
85704, I think.
Pardon me?
I think you're referring to section 85704, definition of earmark funds.
Yes, sorry, 85704.
8, 5.
I was close. I mean,
Yeah.
I was within the range.
Numbers were there.
Very good.
Commissioner Hatch mentioned, range is good, so
That's right.
that's the ballpark exception, right?
Yeah.
In enforcement of this, and so therefore maybe its utility is dependent on, I think, the individual, let's say the treasurer, the campaign committee treasurer, self-identifying and self-reporting a transaction as having been earmarked, right? And an inverse way of getting at that maybe is, isn't it the nature of dark money at the more nefarious end, right? I mean, we're conceptualizing, this cloud of dark money. And at the darker recesses where it's, it's darker than other shades of dark. Isn't largely the problem that a lot of this money moves with a wink and a nod, which then is not reported? So,
Yes,
I mean, I
absolutely.
gather this is a stretch better than whatever has existed before. And, it took, a little bit of time for this to get through. But I'm just wondering, I mean, unless you get into someone's, mens rea, their state of mind, how would you, we are necessarily dependent on people saying, you know what, we're doing dark money, but we ain't going to be that dark, and so we're going to disclose. But isn't the need, I'm asking compound questions, I realize this, but you understand what I'm saying?
Yes, I definitely understand what you're saying. This is something that we've been contemplating for some time now, at how to get at that. And yes,
It's like
it's a
how many
problem.
angels can dance at the end of a pin, right? It's like 2, all? They don't dance? So there's no answer. I mean, is this by definition rhetorical?
I don't want to go to the extent of saying there's no answer. We're trying every day to figure out what the best way to go about that is. In the past, investigations been our strongest tool, but that's where we're at right now.
And record keeping.
And record keeping helps with those investigations.
To your point earlier that, the record keeping is the way to track what is happening. And if it's inconsistent with other evidence, an investigation ultimately overturns the wink and the nod, then we have two different scenarios to look at. Okay, so were there no more questions on the regulations? Because I want to ask for public comment, and then we can have follow-up questions if there are.
I have a question that
Commissioner
back
Hatch?
to Commissioner Adaro's point about the I think it was the last in, first out.
Okay.
I'm a little bit troubled by the example that she gave that means that, in effect, there may be better ways to do this to create maximum disclosure. And especially when there's, as Mr. Cardenas' point, that often these things are kind of worked out in advance, that we don't create a situation where they sort of begin to time these contributions in a way to split a major donation so that it's not required to be used as a top disclosure. So perhaps rather than giving this example, we should be providing language that requires that they do it in a manner that provides for maximum disclosure, as opposed to giving something that in itself is subject to manipulation. So they have a duty to do whichever method provides maximum exposure at the time they're doing it.
I think the last in, first out accounting method is one of the best that we've come up with. I'm not sure what else.
Well, it may be, but just in that one example, it was clear that you could take a very large contribution and cut it down to just $25,000, therefore making it under the threshold to have to be listed as one of the top contributors. So that in itself makes me give pause, because I know that a lot of times this money is coordinated in terms of its arrival time. And so we shouldn't highlight something as okay when we know, in fact, it's not okay in all situations. So maybe the wisest choice is to put in a specific obligation that says you have a duty in these things to treat them in a manner that would provide the most exposure, or not exposure, but disclosure in each case.
So at the very least, at least put something like that.
Right, so
into
which
it.
would
Okay.
sort of force them to say, okay, on this one I'm doing, last in, first out, and this other one I'm going to do some other method because, it minimizes, if I don't, I minimize what otherwise should be highlighted.
Okay.
I think the concern I have is that there is no best accounting method for someone who is intentionally attempting to hide disclosure. I mean, the purpose of the law was to say, if you earmark, which used to be considered illegal, if you earmark in this context, you have to disclose. So I think that, Commissioner Hatch, goes to your concern. I mean, that's why they put this in more strongly. You have to disclose all earmarked contributions, okay? So then when we go to look to the best accounting method, which, as has been mentioned, LIFO was heavily debated and discussed among all the regulated community when we went with the multipurpose organization disclosure rules as the best way to do that. Now, the examples, if someone is trying to split it so they're not disclosed, becomes an enforcement case because it's earmarked and they're taking action to avoid disclosure.
No, if they're following LIFO in that particular instance, they've got, in effect, a safe harbor, even though they know that when they timed those contributions, it would, distort, the veracity of their report. And so I want for us to consider a requirement that in each case they're required to select the method that provides the maximum disclosure.
Right,
Which means they might use LIFO 1 in one instance and some other method in another. I just, I think this is a trap for us, and it would be enforceable, I believe. Galena West is she still here? It might be a handier tool if you have a specific obligation that they must select whichever method in each instance that provides the maximum disclosure. So when you are looking at a case that's brought to you, Galena, that you see that, well, they had anomalous results as a result of using LIFO when they could have used something else to provide better disclosure. And they sort of lived to find the one that would be, if you just said you could use any method you want, yeah, they're going to pick a method just the opposite, the one that provides the least disclosure if they're left to their own devices. And I think we need a positive requirement that they select in each case the method that provides the maximum disclosure.
But I think yeah, I agree. But I think the issue is on the front end, not on the back end. So I think the issue is when making contributions, you can't make them to avoid disclosure. Because again, you're talking about split contributions, because even if you say maximum disclosure on the back end, I don't know how any accounting method is going to force someone to say, well, I'm going to add these two together, therefore they will be, quote, disclosed. I think it's on the front end about the way you contribute an earmark as to not avoid disclosure, which I do think there's language in there, isn't there? It's rather lengthy, but I believe in the Disclose Act there's something about not making contributions to avoid disclosure.
Yeah, there is some language in there.
Yeah.
But it makes it a lot tougher to enforce. I'd like to hear from the sponsor if it's the appropriate time on this issue.
Can I just make one additional comment?
Commissioner Odero?
So I hear everything that's being said, and I am concerned about something that you said, and I'm wondering how we're going to kind of reconcile it all in the end. But you said that there would be a presumption that they have satisfied the reasonable accounting method if they use last in, first out. And if we give that presumption, then I think that we're defeating the purpose, and we are creating a situation just like Commissioner Hatch has raised. So I have a very big concern about this presumption.
So would adding language to the regulation that says something like intentionally trying to get around these disclosure rules would not be, you would not be allowed this presumption in those cases?
How about just taking out LIFO as an example? And how about just leaving it to Galena West and her division to use, to review it under whatever method and to come to a conclusion? And then if we start to see, if Ms. West and her group starts to report back to us that we have a little bit of a problem here, we really need, we're seeing this kind of violation over and over and over, then we regulate. But to regulate just so that we can throw something out there that actually, I personally don't think is helpful. I think it's counterproductive, but just from how it would play out. But that aside, where it creates this presumption, I think is a bad idea.
I would just ask Trish, because again, you respond to the questions on this, and I'm assuming if we take out LIFO, the first question and phone call and email you're going to start getting is, what do you guys consider a reasonable accounting method?
And that's why I suggested what I did, so that they would be obliged to use the one that in each case provides for maximum disclosure, the most disclosure. And I think if you just take the LIFO out and leave it to their selection of the method, then they're going to select just the opposite of what I'm requesting. They'll select the method that provides the least disclosure.
So what if it stayed the language as it is, which is such as, which is an example, as that language means, such as, and then put an added sentence at the end of the paragraph, which says the reasonable method must provide the greatest disclosure, or whatever the language is.
I would take the example out and instead add the sentence that requires that in each case that they select the method that provides the most disclosure.
Madam Chair?
Commissioner Hayward?
I think if we're going to start doing that kind of wordsmithing to this, we need to bring it back. It's not at all clear to me that we can go beyond just saying reasonable accounting method, because that's what the Disclose Act said. And we're starting to, I think, get into a little bit of, self-legislating, and I'd want to give people who have thought about this question, a long time, the opportunity to talk about it with us by way of comment letter and whatnot before we make any final decision.
And along those same lines, I guess I'd like to be able to highlight some of the language that's already in the Disclose Act, which I think may get at some of your concerns and whether we repeat it or not, but I don't have it in front of me, so I can't pull it out. But I
just don't think that it's adequate to leave it to their own devices.
No, I think this reg's going to be
back and forth, LIFO, FIFO, back and forth. And this is an area where the creative accounting is born. And in the example that was given where the money passed on was less than the aggregate of that earmarked. So that means that the committee that's receiving this money can artfully decide what size checks that they're going to write to pass on based upon how they can provide the minimum amount of disclosure. And I think it's too mischievous. I get that it's probably not good for me to just write the sentence myself and have it adopted. I'm fine to carry it over, but I would like the sense of that to be in your uppermost mind when you're rewriting this.
Commissioner Cardenas?
I don't know what the grace period is for the new guy asking dumb questions, but I'm hoping it hasn't expired yet. Was there any thought given to just largest to smallest? I mean, there's darkness and then there's weight. I mean, if a $500,000 contribution is far and away the largest that was made to a particular committee, but it also happens to have been, the fourth one receding in time, why not include it?
Okay, that's something to think about too. I mean, it's sort of, when it comes to that being the fourth donor, you're right, we haven't really thought about that, but they are required to be listed when it's the top three, the highest one first. But when they're the fourth one out, no, we haven't thought about that.
I want to hear from, if you have other questions regarding regulations and obviously the public, but I'm just going to throw out the idea that we don't vote on 18401 today and we think about these issues and bring that particular one back.
I would like some language brought back to us that reflects the concept that.
Sure, but I'm just saying that for right now,
that they want, but I want to see that when it comes back.
But I'm just throwing that out as if we're going to continue to talk about 18401, if there's questions about the other regs, because we do have 8 other regs that if we're going to hit on those and to hear from the public. That's what I'm just saying. If we're going to bring it back anyhow, we can flush out all these a little bit more. I think a lot of issues have been raised that can be addressed at an IP and brought back. Commissioner O'Darrow?
So I completely agree with that approach, but I would like, as part of what's going to be reconsidered, is the new record-keeping requirement.
Okay, so commissioners, questions on any of the other remaining regs being proposed today? 7. Okay, so let's hear public comment on the regs. And Mr. Lang, if you can address 18401, obviously, but also understanding that it sounds like the approach is going to be that we're going to put it over so we can flush it out more.
Yes, absolutely. Thank you. Trent Lang, President of the California Clean Money Campaign, the sponsor of AB 249, the Disclose Act. First of all, we'd like to thank staff for working so well. Is this not? Oh, just closer. Okay. First, I'd like to thank staff for doing such a great job on this entire package of regulations. The rest of these regulations here today, we are perfectly happy with reflecting the intent and code of AB 249. We do think in general that it is important to have this kind of record keeping as an addition to all the other record keeping, because this is a kind of a new kind of requirement. It's one thing for a committee to know that they have to keep the checks and, you know, the invoices and that sort of stuff. That's relatively simple, but this is admittedly more complex to have these new earmarking rules so we can trace the dark money through different areas, and AB 249 does clearly spell out, perhaps not as clearly as it should on the reasonable accounting method, the different steps that it has to be done where earmarking funds are divided up when they are given to one committee or to another. So we think it's very important to have these in here, though we're happy to see some of the clarifications. In terms of the reasonable accounting method issue, I think we would have some concern about committees potentially picking and choosing which accounting method they would most want to have. We'll have to think a little bit more about whether or not how difficult it would be to require them to choose the one that has the most disclosure, because that may depend upon where they ultimately give the money to later on, which committees. The issue here is in a case, in sort of the example that you gave of a part of the money being earmarked funds being given to one committee and then one of the big checks being divided up. Now, that $25,000 doesn't go away if they then give that same contribution to the original, give more earmarked funds to the first committee that they gave to, then it would accumulate in that committee as being earmarked and it would add up in that same committee and show the full $100,000 in that particular case where they had it divided up in the different cases.
But that donor may not be listed as the top.
Well, they would be on any subsequent, if they give, in this example where they had $250,000 earmarked ones that were shown for sure, and then a $100,000 one that only $75,000 was given. So first off, when they give to that committee 2, which is then doing an ad, that $75,000 may put them over the limit to be a top contributor on the ad.
Or it may not, depending upon how they manipulate it. If they have the ability to manipulate it.
Right. So, but if they then give another check earmarked, if they then give another earmarked contribution to that same committee, which would then, that remaining $25,000 would be the very next chunk that would go in under the LIFO rule, then that $25,000 would add up with the original $75,000. They'd have $100,000 in that committee.
But wasn't the question really more what happens when that $25,000 is given to a different committee?
Yes, that's where that would be a potential challenge. Now, I will note that if that third committee had received funds from that same contributor directly or through some other means, then that $25,000 would add up to it. So, yes, there is definite possible gamesmanship in that sort of thing in terms of dividing it up. It's not necessarily only because of LIFO. This approach is imperfect, we will readily admit. But so I think these are important questions. I don't know that LIFO per se is necessarily a problem, as staff has pointed out. That is something that the Commission uses in other
your alternative
means.
definition, or not definition, but your alternative facts. Couldn't it also be true that big contributors that only got a small piece, added or counted in that disclosure, then be not counted at all because there are subsequent big contributions that come in that wouldn't then make that one not even on the next list?
That is possible. And so, I mean, the challenge there is contributors kind of purposely doling out earmarked funds to multiple different committees. And, and they could, they could do it in other ways. This LIFO thing doesn't necessarily have to come into effect. They could give $49,000 to the committee, then it gives it to committee 1, and then 2 weeks later they give another $49,000 to the first committee, which then gives it to committee 2.
Right.
So there are other ways they could do this sort of thing. I mean, the good thing is that these will all be disclosed on their online websites, and if any committee plays these kinds of games, it will be obvious to the public and people who are watching it. Not necessarily to put it on the ads, but people can at least bring attention. Hey, why are you dividing up all these $49,000 earmarked contributions? That seems like you're playing games.
But unless we provide a clear tool for Galena to enforce, these games will happen even though people go, that's terrible.
Yeah, I mean, I think we're perfectly okay with listing LIFO as one of the examples. We're looking forward to working with the Commission on possible follow-up legislation to clean up some lack of places where there are could use more clarity. This might actually be one of those sorts of places that we'd be happy to discuss with the Commission and staff on.
All right, thank you.
Any other questions for Mr. Lang? Okay, thank you. Any further public comment? All right, is there, so again, putting aside 18401, perhaps there's a motion for approval of the remaining amendments and repeal?
I'll move approval of amendments to regulations, all of them listed in the agenda except 18401. Is that an okay motion?
Yes, and then that includes repealing
Yes.
the one reg that's listed as well. Is there a second?
I'll second.
Okay.
Commissioner Darrow?
Yes.
Commissioner Cardenas?
Yes.
Commissioner Hatch?
Aye.
Commissioner Hayward?
Aye.
Chair Remke?
Yes.
Motion passes.
Okay, thank you, Suki. We'll Okay, so item 26 is the Bagley-Keene Open Meeting Act additional questions. And Commissioner Hayward, you have requested this as a further item, so if you'd like to take the lead on this?
Sure. As we will all recall, last fall we had a work session with representatives from the Attorney General's office to talk about the Bagley-Keene open meeting law and the rules that it requires of us as commissioners on a state commission. During that workshop, we had a number of questions for the Attorney General's office that, at least in my esteem, were answered with rather vague advice. I mean, several times they gave us the caveat that what they were trying to do is give us a best practices type advice, which is fine and totally appropriate for a workshop like that. But the problem is there isn't a lot of definitive advice regarding what is permissible or impermissible under Bagley-Keene, especially as it involves commissioners and members of the public. And so I think it would be appropriate for our commission to seek advice from the Attorney General's office with particular, not abstract questions, particular hypotheticals to make this business a little crisper. I say that for a number of reasons. I think it is chilling when members of the public hear about a problem with Bagley-Keene that may involve them approaching a member of this commission with a problem with an agenda item or a problem with just the general law or whatever. At one point, the Attorney General's office suggested that if a member of the public emails all members of the commission simultaneously, that is, I can't remember what, asking for trouble. That is, looking for problems. I can't remember the exact expression. It's here in the minutes, but I'm doing this off the cuff right now. So anyway, and I think that is chilling. I'm not sure that Bagley-Keene prohibits that sort of conduct. And moreover, I would like the Attorney General to confirm that Bagley-Keene means what it says and that that conduct is okay, because I would rather not have some member of the public who doesn't like member of the public number one's opinion to attack us or that person as potentially violating the act, to create some sort of other political dynamic going on in what I think ought to be a fairly straightforward analysis of the law and the regs and how they apply to everyone. Most of the concerns I have regarding what the Attorney General's office was telling us in vagueness are from pages 11 to 15 of the minutes from that meeting. And so I think I would like to propose, because I seem to be the one that's worked up as much as anyone about this, is perhaps I could work with staff to come up with some hypotheticals that seemed reasonable, not weird, quirky, catchy ones, but ones that actually reflect what happens in the experience of a commissioner on a commission, where so little of what we do can be done outside of an open meeting. And maybe, bring that before the commission next month with the idea of submitting a question to the Attorney General.
I'm going to ask that John Pazer respond. I guess I think that's a good proposal, perhaps, that you guys work together and he can create a memo based on your concerns that we've raised, the kind of big picture items. I will say my understanding is I don't know if we'll get very far if what we're proposing to the AG's office are hypotheticals. So I'd want you to respond to that as well, please.
Right. Thank you, Commissioner. Commissioner Hayward, yes, I'll be happy to work with you on that matter. The memo that sets forth the process for bringing something before the Attorney General's office for an opinion requires questions of law. So hypotheticals might be difficult. So we will have to work on that. I mean, that's I think the biggest challenge is setting forth what questions we're going to pose to the Attorney General's office. And of course, the other problem is the timeliness. Attorney General opinions can take 2 years. So that's another issue. But those are things that you and I can discuss.
Yeah, I guess in response, I think by hypotheticals, I meant things that happen in real life cleansed from the identification of the people involved. So person A is a real person who did a real thing, but we're not going to tell the Attorney General what his name is just because we're her. And then, as far as the timeliness, just to make everyone clear in sort of why I'm concerned about this, at least we will have asked.
Yeah.
So at least when someone comes forward and tries to sharp elbow someone who is, as a concerned citizen, trying to reach out with a concern, we can say, listen, that's not how we read it. Moreover, we've asked the Attorney General to confirm that reading, and when we hear from the Attorney General, then we'll know. But it troubles me in an area that's so fraught with First Amendment values on both sides that the vagueness and the sort of air waving is what we seem to be dealing with right now.
So if, and I'll hear from other commissioners, but if that's an acceptable process, and so again, to avoid Bagley-Keene issues, I would have Commissioner Hayward work with John, come up with a memo kind of highlighting the questions, and anyone can now speak about those questions, but we'll bring it back so everyone can see it and work off it and add to it or change the language or feel like it doesn't cover an issue they may have concerns with. But at least we'll have a starting point with some language, which will be easier than talking in the abstract. And then from there, we could talk about if there's a agreement and a motion to present it to the AG's office.
If I may, Madam Chair, if anybody's else going to comment, just to get this in full context, the AG opinion process requires that the requesting agency staff provide a legal analysis along with their question. So in the short term, and for Commissioner Cardenas and everybody, of course, knows or should know that FPP staff, legal staff, is available for any answers to any questions at any time, including Bagley-Keene. So, and we will, in this context, for Bagley-Keene, we would consult the Attorney General's office as well, the experts, Ted Prim, on any specific questions that we have in the short term while we wait for an issue on the larger, broader question that we would present to the Attorney General's office. So
And
just know
it's
that.
our legal counsel. Anyone can contact you confidentially if they just have an issue that feels more sensitive. They can get a feed from you. If they think the issue is important enough that they've asked you, you could always bring it back in a memo to the full commission to hear and review and discuss. But as far as this particular issue with that training and issues that Commissioner Hayward feels have been raised, I think the approach would be that you'd work with her, come up with a memo, which would include some legal analysis, it sounds like, because we have to do that. Bring it back to us, and we can add, change, or decide where we want to go from there.
Madam Chair,
Commissioner Hatch?
Mr. Fazer's remarks kind of fed right into what I was going to raise, and that's that we have legal counsel. Is an opinion from our chief counsel on a subject matter like this binding upon us, or is it just a recommendation to the commission, unlike an attorney general's opinion?
An opinion in the sense of a formal opinion?
Yeah, written opinion, formal written opinion.
Formal written opinion that doesn't require voting, I just, not the opinion
Opposed
process.
to a commission opinion, which is a whole different thing.
If you're asking for advice from our staff, that's not binding on you, it's just our advice.
No, I'm not talking about advice. I'm talking about if
It's not going to provide you immunity.
poses some questions that require, is this allowable under the law or not allowable, certain conduct, and one route is to take it to the Attorney General, and maybe ultimately that's what you want to do. But in the meantime, besides just specking it up, is it not a possible option on some of these to be able to just ask our chief counsel to render a written opinion on the the legality of the various items that are put before them as a legal opinion of our chief counsel? And my question is, does that have any weight as opposed, I mean, is that just an exercise?
Commissioner Hatch, it has weight to the extent that we reference the law and we give you our recommendations based on the law and the facts that are at issue. So it'd be like any attorney-client communication. It has the weight of the law that's being utilized to give the recommendation.
Yeah, I'm talking about a published opinion.
Like a published opinion by the commission or by the AG?
By the chief counsel's office.
So then you're asking for a request for advice, and it becomes an advice
No, I'm not
letter?
talking about personal advice here. I'm talking about
Well, there's-
a general application on a certain class of conduct. Like, any one of these lawyers out here want to contact any one of us individually, is that allowable or is it not? I know there's some that would like to say you shouldn't do that, but I want to know what's the law. And I want it to be, that opinion to be available to anyone in the regulated community to read and for us to know.
Right, and I think...
I don't know whether it would be considered binding on us for our future conduct or whether it's just advice.
Right, and I think the law is binding. I think Chair Remke sort of referred to this situation. Let's say a memorandum came out as part of the agenda, it was considered by the commission. That would be something the commission would vote on, and we can move forward. Like, for instance, if we brought this before the Attorney General's office.
Well, you said yourself we're not going to get an answer on any of those questions for quite some time. And so I'm looking at it as possible to facilitate to do a dual process where we take some of these issues and turn them into chief counsel's opinions that are available to the public as well as ourselves.
And I think my only point, Commissioner Hatch, is I'm not sure there is such a thing as a chief, a general counsel opinion. I'm just trying to clarify. So I'm just trying to think of how the way we get to what you want is all I'm saying. There's not a formal chief counsel opinion. That's why I referenced the advice letters. That's what they are given, and that does provide immunity under the act, but this is outside the act. So I guess the thing is, part of this is...
They're Bagley-Keene issues.
Right, which is outside. So they cannot provide immunity. Their advice cannot provide immunity. All it is our legal counsel. It would be us acting in good faith based on their advice, which begs the question, if we have questions for them, and if they give us answers, and if we agree to abide by those, it's kind of like our own governing principles, let's say. And we're acting within the advice provided that we all vote and agree upon. The question would be then, who's challenging that? So that's their advice is solid, we agree, we move forward, and we all agree. I don't know if there's a violation of the Bagley-Keene is either a criminal violation or a civil action to void the action, right? Correct? So again, the likelihood of either of those happening is unlikely. But if our goal is to have a common understanding of what we can or shouldn't do and work on that together and agree on that, I think that could be asked in this process with Commissioner Hayward perhaps starting it, shaping out some of these issues, getting our own legal counsel's legal analysis as they're required to do. At that point, we could decide if we agree, if we want to pursue AG's opinion, or how.
I don't know. Commissioner Hayward did a great job of trying to corner some of the folks that were presenting this orientation, to try and corner the AG staff on some of the critical questions, and they dodged them. It's maybe the unvarnished version. And so now we're looking at, we're going to take us 2 years to find out what it is that we care about, or is there a way to, like, not in lieu of this, but in compatible way, do both?
And I think that's what John is suggesting, is a two-step process.
Of course, what I was asking was, if we were to do that, does it have any weight?
But again, I think the issue is the weight in what context other than we self-regulate ourselves. We can agree to this as governing principles, which that's some weight.
Well, let me give you a parallel example that's quite commonly done in the legislature. They have an Office of Legislative Counsel that drafts their bills and whatnot, but also any member can ask for a Legislative Counsel opinion that is published,
right,
that governs that subject matter as to what's lawful and what's not.
And that's why I just commented that we don't have that process here. I just wanted to make that clear. Not to say that we can't get there in a different way.
They have the authority that's never been used.
But I think it would be, we would want to adopt our own rules. That's the point.
I asked the question of our chief counsel.
Do we have a process in place for you to issue?
Ask for a process in place. Do you have statutory authority to issue opinions on issues brought to you by us?
No. I can issue advice in the form of a memorandum, which is submitted to all the commissioners, but the weight of that I don't think is what you are looking for in an actual opinion. Any opinion, I think, the only type of opinion we have is one that is considered by the commission and voted upon and approved. As far as my authority, it does not go that far.
Yeah, those are on interpretations of the law that we operate under, the Act, right?
I'm sorry?
Those are for interpretation of the Act.
Correct.
Right, within that context.
Right.
So you think it's silent on it, or you think there's anything that isn't an impediment?
Yeah, I just don't think there is any avenue for me to take to issue the type of opinion that you just gave an example of with the Legislative Council.
Okay. No parallel authority?
No.
Okay.
Can I ask a question here?
Commissioner Odero.
Are you saying that you don't have the authority to do that because it's the Bagley-Keene Act is not within the jurisdiction of the commission?
I think that's one aspect of it. But the bigger picture is I don't think I have authority that would in some other venue provide you with immunity if I issued some sort of opinion. What I can do is provide you with advice. And whether you choose to accept that or not is up to each one of you. But the weight of that advice, as far as I know, pretty much stops here. It has no weight in other venues, so.
Perhaps good faith.
So the reason I ask is because in October, I actually asked that very question that I just posed to you, which is the Bagley-Keene Act under the jurisdiction of the commission? And the reason I asked that question was because what is a meeting necessarily requires in its definition that we be discussing things within the jurisdiction of the commission. And so my question was, oh, well, wait. The Bagley-Keene Act is not, I thought, within the jurisdiction of the commission because it's nothing that we can actually affect. And the answer was surprisingly different. It sounds like you and I are on the same page, but if you look at page 14 and 15 of October, I got a totally different answer than I expected. So I said at the bottom of page 14, would a discussion among the members of our body about the Bagley-Keene Act be a violation of the Bagley-Keene Act, since that's not really under our jurisdiction? And the answer was, well, but complying with it under your jurisdiction is, so we would say yes. So now I'm thoroughly confused. Is Bagley-Keene Act within our jurisdiction? If it is, then my question to you is, then why can't you issue an opinion? Because it's within our jurisdiction. And if it's not, then who's right here? Is it? Or according to Ms. Zufilato, it is within the jurisdiction of the commission. I'm thoroughly confused, and I hope you can clarify.
Well, we, of course, are subject to the Bagley-Keene Act, and to the extent we have provided advice about whether something falls within or without the act itself, we can do that, but it's not within our jurisdiction to the extent that we can regulate it and
affect it in any way.
Affect it in any way. I can give you advice. That's where it stops and starts, or starts and stops.
Yeah. Okay. Well, and then I guess the question is your advice privileged, right? And I have a concern. I mean, we can choose to waive the privilege.
Yes, I absolutely, I believe so.
So if we are asking you for advice, then, and we want your advice to be made public, I think is where you're going, Commissioner Hatch. And also where I think Commissioner Hayward is going is we want to make sure that the public knows it's okay to call us or whatever the rule is. So you could give us advice under privilege, or we could choose to waive the privilege.
You know, I believe so, and I'll look into that to make sure, but I don't see why it has to remain privileged. I think it's our decision whether it's privileged or not privileged.
Our decision, but yeah.
Or to waive the privilege.
At the end of the day, the bottom line is if you give us advice and we rely on it and it's wrong, and I'm not suggesting you would be wrong by any means, and it just happens to be wrong, that doesn't save us. Right?
No,
We're still out there. We're not going to go talk to Jack. So
you can point a finger at me. I mean,
okay, fair enough.
Through the bars.
Thanks.
So at the end of the day, I mean, we still need the AG's opinion, the formal opinion from the AG, whenever it may come.
I see that now, yeah.
Okay, so unless there are further questions or issues, I guess I would just start with, is the proposal that I suggested adequate for your request?
Yes, I think so.
And so do the rest of the commissioners want to add to that proposal of Commissioner Hayward meeting with John to come up with some scope of questions, bring it back to us with the analysis, and if we want to add to it, change it, we can do so at the next available meeting. And if you have any questions now you want to throw into the mix, go ahead.
And that's where I was going.
Okay, so
I don't need to throw my questions in, but I went through it all thinking that that's what we were going to do today is come up with the questions, but that's okay. I have my 6 questions. The only reason that I want to participate in this process somehow is that my questions exceed the scope of pages 11 to 15. So I think that there should be a mechanism through which the other commissioners can also submit questions, and we can talk about what that is and just make it easy and then the whole host of questions that will be submitted and reviewed by whoever then is presented at the next commission meeting, so we can save ourselves some time.
So why, and then, John, let me know if you see any concerns with this approach, that Commissioner Hayward can take the lead on this and work with you, but that any commissioner can directly send you questions to add to the scope of that.
Yes, that would be welcome, and the more questions, the better, so we exhaust all the issues that you have.
And I have a question about the procedure. Is it actually correct that the AG has no time limits to answer our questions?
No time limits.
So does it make sense then to send one letter with a whole bunch of questions and then have it, not get answers until every single question can be answered? Or do we send separate letters? I just think about it. I don't know what the best approach is.
But I'm hoping that Commissioner Hayward and John can work together to kind of narrow similar questions and maybe more group them as broadly to get the answers as concrete as possible, but without having a list of 20 if we can avoid it. But we'll see what happens. So that will be the approach we take on this. So commissioners who have any specific questions, to just email John directly with those, and John and Commissioner Hayward will work together to flush out a process and bring it back to us. Okay? Thank you. So item 27, letter regarding closure of Eric Lucan matter, case 16284. And this one, Commissioner Odero, you requested that it be placed on the agenda, so I'm going to let you take the lead.
Great, thank you. So when I read the letter, the reason I requested it be put on the agenda is I wanted us to have a discussion somewhat about the ultimate conclusion, but more about process, because I was a little bit concerned about what appears to be an extremely lengthy process to resolve something that apparently we'd been giving verbal advice on in advance of when he actually asked, and maybe even in advance of the complaint. I don't remember exactly what the details were, but I'd like to kind of talk through and kind of get the story, the history of this from you, Ms. West, so that we can use this as a basis, not to change the result necessarily, although I have some questions about that, but to actually start a conversation that I would like to make the bigger picture conversation about process. But before we get there, I'd like to talk about Mr. Lucan's concerns and what happened here.
Certainly, Galena West, Chief of Enforcement. Conflict of interest cases are time-consuming. They basically are. When you read the regulations, step 1 through 4 under the new regs, you have to figure out reasonably foreseeable and materiality and trying to make those determinations. And there's a huge difference between the advice function and the enforcement function. So with the advice function versus the enforcement function. So when you write an advice letter, you take the facts as presented generally with few exceptions, and you answer the question asked. When you have an enforcement case, you assume that you have to verify every fact. You can't only answer the complaint. You have to also look at the entire global holdings of the person as well as other decisions. Because I can't present a conflict of interest case settlement to you on one count that was in the complaint without looking to see if there were other possible votes or influencing or participating or other properties. And so, unfortunately, otherwise you would get case after case, because then a complaint would come in, they saw that on the agenda, oh, but he also voted on this. Didn't you guys look at those minutes? So in a case like this, you have to look at I'll give you great examples. This is a case about a smart station. So we had to look at, talk to the smart manager about the various elements, track the infrastructure, get the schedule for servicing to the downtown station, figure out the ridership, and were anybody else on any other smart planning boards and committees, were there alternative station options? Where would it stop? Where would it start? Who would it benefit? The reduction of the Marin Transit Authority of bus service in the downtown areas, the funding sources, the likelihood that the project will move forward, the mapping data and the survey maps. It's within 4-minute walk, but it's also within 800 feet. So we have to look at all of those things. We have to look at the comparison travel from the property on, does this actually benefit it? And then also, we had been given a lot of different surveys that had mapped in other jurisdictions whether public transit stops near a property is a benefit or a detriment. So we have to read all the studies, decide which ones are applicable, because of course they're not on this jurisdiction, they're on other jurisdictions. So you have to gather all of these facts. You can't take the facts as presented to you. So that's what we did, and that's what we spent the time doing. And we opened this case in March of 2016 and closed it in November of 2017. And all the while, Mr. Lucan was getting advice on other properties or other decisions. But that doesn't preclude us from having to look at everything that's going on in the case. So with conflicts cases, when you're saying step one, is it reasonably foreseeable the governmental decision will have a financial effect on the public official's financial interests? You have to figure out what everything is, what decision you're talking about, and then go through the steps to apply those standards. Because within each standards, there's 10 subdivisions that you have to figure out which ones apply and which ones don't. And then look at public generally to make sure that it's not something that you can also foresee as a reasonable defense. So conflict of interest cases, they're complicated. They're entirely fact dependent. It takes a really great personality of an investigator to be able to follow through and to put all the pieces together. And I think that the investigator and the attorney assigned to this did a great job, and I think it was a reasonable amount of time.
But other than the difficulty of conflicts case, which I understand, and we could talk about that if people want to, just the standards and where we are now, but was there any other thing particular to this case that drew it out or sped it along? I mean...
Well, there was the original complaint, and then there was an additional complainant, and then the additional complainant sent in extra information twice during the investigation. The respondent, Mr. Lucan, had a attorney who presented quite a bit of information in defense, 9 or 10 different advice letters with different fact patterns that we had to go through to see if any were applicable. Then we also had to, he then separated from his counsel and then deal with Mr. Lucan individually and then start over from wherever you were. And then getting individuals to contact you is sometimes a little more challenging.
So, who shut down his advice on other unrelated projects?
On the related projects?
He complains that he couldn't
Sure.
get the advice, told him he couldn't get advice anymore because this pending.
He couldn't get advice on the smart station that he had proposed.
He said he asked for advice on unrelated projects. Is he not right?
We generally decline advice anytime the underlying facts would be related to the matter in enforcement, and we generally
And why don't you introduce yourself?
I'm sorry. This is Brian Lau, Assistant General Counsel. So if the underlying facts are part, or so if in this case we did decline advice 3 times. Once was on the exact same project. So there was 2 other ones that were different projects, but were similar sized projects within the similar distance from the exact same property interest that was subject to the enforcement complaint. So those were the 2 that were declined.
One he says it was on the other side of town.
But did we provide any advice?
We did provide advice in one case on in the situation where it was the other side, a different project, different property interest on the other side of town. We provided advice in that scenario.
So I'm sorry, did we just provide advice once? I thought there were 2 formal letters of advice provided.
During the enforcement proceeding, we provided advice once. We provided a second advice letter nearly simultaneous with the closure as soon as as soon as the enforcement matter was over, we provided advice rather quickly on the second question. So, and I also believe there was an email at one point that we provided advice that was because of the nature of the project was somewhat different. While it was the same interest, the nature of the project was much smaller, so we provided an email advice assistance in one instance during the enforcement proceeding as well.
So if I have, just to kind of understand, because I looked at his maps, property here, okay? Project A is over here, project B is over here, project C is over there. Are you saying that because the question involves this same property, you can't answer about project B or project C?
That is our current policy, yes. It's more of trying not to interfere with existing enforcement and trying not to interfere with the commission's oversight of enforcement and enforcement matters. By issuing advice letters related to similar fact patterns, those advice letters are essentially used by the attorney. In this case, the actual letter that we wrote that we did provide advice in was used by the attorney to argue why the enforcement matter should be dismissed.
And that's okay. There's nothing wrong with that in my mind. Why not? If you're saying, if what their argument is, wait a minute, you're telling me I can't do this, but you're telling me I can do this, which is the exact same thing, only in the other direction. Why would that be bad? Why would we not let somebody do that?
I think our longstanding position is that it would be inappropriate for the legal division to ultimately determine or affect enforcement actions based on providing advice in very similar circumstances.
But how is that affecting an enforcement action that has to do with a different project? That's number one. But number two, we can have longstanding policies all we want. And somewhere along the line, something hits us in the face, and we get to look at that again. So I get that until, based on that policy, that's how this case was reviewed, and maybe we need to look at that going forward. But I have to tell you, I don't think that it's a valid reason to say, first of all, you're using two different terms. You're using related and similar in the same sentence. And I think that those need to be completely different standards, right? I mean, if it's related, right? If it's related to Project A, and you're going to make it some subpart of Project A, okay, all right. But if it's a similar situation, but in the other direction, why not answer that question? I mean, here you have somebody who has the obligation to vote on things in the city council, right? On measures, on things that are brought before the city council. And we are basically saying, not touching that one because we're busy with this one. We know it's not related, but it's similar. And I just find that, how does somebody then get what they need from us?
From a very practical matter, if we allowed for them to seek advice just because related to the same interest on a very similar project, legal would be used as an avenue to undermine enforcement actions.
Well, it would be precedential, right? You're saying we would make decision A, and then decision A would be used to what? Support what they want in decision B that they didn't get? I mean, that's how precedent works. How do we take a position on something and then say, but we don't want that to apply. Let's just kind of hide this one.
I believe the rationale has always been based on enforcement does a more thorough looking at the actual facts of the case. So legal division would be giving advice on the facts provided by a respondent in an enforcement case, mirroring a active enforcement case as much as they possibly could, crafting those facts, getting immunity, and then using it in the enforcement action. So I think that the precedent was set to not do that, if it's similar enough in fact pattern in order to be an end around of actually getting a full investigation. And if it determines that there is something there, a determination by an ALJ of all the facts.
But see, I guess the concern, and this maybe goes also to what you were saying, what you were explaining earlier, that enforcement is not going to just look at what the complaint is, but you're going to go out looking for anything you can find. And I find that in itself troubling. Because as I defend employers, this is what I do for a living, right? It's a little bit different, but my employers go before agencies. And if a complaint is sexual harassment, right? The EEOC, or in California, the DFEH, isn't going to go sniffing around for disability discrimination. They're gonna look at what was charged. So expanding an investigation into something that wasn't even brought to you, I think, is something that really needs to be looked at. But I guess that's what kind of gives enforcement the ability to say it's all kind of related, because we're just looking at everything. And that to me just kind of seems overly broad.
I understand your concern. That is not what enforcement does. I think that's a slight misrepresentation of what I said. What I meant was, when it's a conflicts case, you don't leave other conflicts on the table. You don't turn a blind eye. You don't say, I know you voted on January 26th and you also voted on February 1st, but we're not going to look at that because that wasn't in the complaint. So if it's in the same realm of conflicts and disclosure, then yes, we're not going to look like an idiot the next day that we presented a complete case to you, that we said this was the investigation of this case. And yes, he did it the next week, but we didn't look at that, because that would not be fulfilling what we're presenting to you as an actual complete case. So am I going to go look at his campaign statements, and am I going to go see, the other parts? Is he registered as a lobbyist? No, probably not. That is not really in the realm. But I am going to be thorough and look at the decisions that relate to this and his other properties. Because if you own multiple properties in the same area and the allegation is you are voting to benefit your property and came up with the whole scheme in order to benefit your property, then I have to look at your other properties.
Why?
Because if they are also affected by the decision, it is relevant.
Oh, I see. You're saying that the scheme is to benefit all the properties, not just the one that is brought to you as part of the complaint.
Correct. So when you look at a case, you can't just look at that one piece. You look at it as SCIs and you say, okay, there's other properties in this area. We should also look to see that as well. That's what I meant.
Okay. So a further question that I have is about all the investigation that has to go on, because as I understood it, and correct me if I misunderstood you, but as I understood it, you were saying we need to look at all, the time travel and all those things that you listed that and I don't know, but you have a list, so that you can make a determination whether a reasonable person would believe that there's a conflict of interest. But wasn't did I understand that right?
Sure.
Okay. So, but wasn't the conclusion that, didn't we say, we don't really know the effect that your vote might have had on the value of the property, but that doesn't matter, because a reasonable person could have concluded that your vote would have somehow added value. And so, added value to your property. And so, I guess my question is, if we're going to disregard whether we can figure out if a reasonable person would think that the property value might have been affected positively, why do we have to look at all of that? Why do we spend the time looking at all of that? If the answer is really, let's just find the reasonable persons and ask them, what do you think? Do you think it would have been affected? Because that seems to be the conclusion here.
That was not the intended conclusion of the letter, and reading that paragraph, it just talks about how it is unclear if the vote would have the effect on the value of the property and the rental income. And then it just shows the alternative to that, which is why we did not make a conclusion on the case. So when you look at the standards of reasonably foreseeable and you look at what we need to determine, you look at these factors of the extent to which the occurrence was contingent upon intervening effects, whether the public official should anticipate a financial effect as a potential outcome. Would it's a decision that would be typically affected by the terms of the decision? Might it compromise the public official's ability to act in a manner consistent with their duties? Would it create an advantage or a disadvantage? And that's only some of them, and there's more. And so when you're deciding an enforcement case and whether to move forward or not, these are every single factor that you have to go through to see if they apply. That was all my point was earlier. So the letter does not make a conclusion one way or the other, and that's why it has both sides.
So, okay, so now with having you read off the factors, that's very helpful to me in understanding why you were looking at some of these other things, because the second one, I think, was, you know, what was the second one? Would the
Anticipate
elected
a
official-
financial effect of a potential outcome?
Right. So I can see where you're trying to figure out, could there be, right? But then I guess the question for me becomes, who are we to make that decision, right? I'm not an expert on this. I have no idea. You could conclude, reasonably so. I mean, there are many situations where reasonable minds could differ, right? And you could conclude reasonably so that having an Amtrak station, 800 feet from your property would increase the value, likely would increase or could increase the value of your property. And I could come back to you and I could argue the complete opposite and say, are you kidding with the noise that it makes? Who would want to live that close, right? So who are we to make that decision? So I guess the question to you is, what experts are we looking to help us make these decisions, or are we just saying we're the experts?
We look to the legal division. So basically, those advice letters that you approve every month are our guidance as to what factors are the most important. What is considered a conflict? What is not considered a conflict? What is the weight given to number 3? What is if there are similar decisions? So many conflict decisions are based on property issues. So it's zoning, or it's a new station, or it's planning, commissions making decisions. It's the financing of these programs. It's the grants to get these programs. And those all take research to even understand what it is you're looking at. And so when the legal division does a thorough analysis on these types of decisions, we use those as the guide. And then we gather the evidence to weigh it on each side to see where it falls.
But the decision that you're making is whether it would be reasonable to conclude that the property value would be affected one way or the other, right?
Certainly.
So are you saying that do we have advice letters that say if it's 1,200 feet, I'm not saying exactly, but to the effect of if it's 1,200 feet, not affecting it one way or the other. If it's 600 feet, affecting it. And then you go, oh, well, we're closer to 800 than we are to 1,200. And so is that what we look at? Because that's the question that I'm asking you, is because you would agree that if you thought like I did, like who would live near an Amtrak station, right? Mm-hmm. The fear would be the property value is going to decrease, right? Because it's horrible, it's noisy and dusty and whatever, soot and whatever, right? So if the answer to that question, could somebody reasonably conclude that the value of the property is going to be affected positively, turns on that opinion, who are the experts that we're using? Is it us?
It becomes you, because that's exactly what the studies showed. This is why the conclusion of this case is what it is. The studies show in more affluent neighborhoods, it's considered a detriment to property values, and in less affluent neighborhoods, it's not. And it's considered a benefit. So if for a rental income, then you have to weigh that, and then who goes out and judges which kind of property this is that we're talking about in Novato. So
it's expert reports that you're relying on.
Right.
Yeah,
so you pinned exactly what the issue is in this case and why we concluded it to say the legal division is the experts. Go get the advice. We don't want to hinder that process.
Because ultimately, based on all the investigation you did with that laundry list in the beginning and the expert reports which you review, if you can't come to an agreement, which you present to us, and then we become the arbitrators, you'd have to take this case to an ALJ, and they are going to decide whether or not a reasonable person.
Correct. They would apply our standards.
So also, which leads to why these cases become more complex, because if you can't reach a resolution, you got to prepare for trial, which is to present all of that information to an ALJ to make the decision. But I would just say, as far as procedure and the process goes, I guess I'm not sure where the problem is, and because I think the problem in this case is that Mr. Lucan asked for advice 6 days before he was going to vote, despite from at least what some of the information we've been provided says that he was well aware that this was an upcoming issue and a potential vote long before that. So,
And also to seek advice 6 days before he voted.
but the law says in the act, not even our regulations, the act says minimum 21 days to request advice.
Right.
To request
That's
written
the
advice.
statutory deadline for providing advice.
Written
under the
advice?
act. Written advice under the act.
And he was quite
Also previously had asked for verbal advice.
on other issues.
On other issues, and he's also relying on advice that he received before the conflict of interest overhaul that started in 2013 and finished in 2015. So he had received prior advice under different rules and was informed of that when he called, in his initial request when he called, I believe he even spoke to me, was told that the realm has, that there was a conflict of interest overhaul, the materiality rules had been changed, and that he did need to seek advice because we don't have past advice letters out there that are now controlling.
Is his statement in his letter correct that he got verbal advice by phone, and when he requested that somebody confirm it in an email, that was denied?
I can't find, I don't have any record of him requesting it by phone, and I do not, or that he was denied, or that I don't have a recollection of whether or not when he spoke to me initially, whether or not he had mentioned that he received conflicting advice. I do not, I don't remember him saying that. I don't remember the conversation that well. It's been several years now.
So in the 2 years I've been here, this is not the first time I've heard of conflicting advice, right? Where people have called and said and gotten something over the phone, and then when they asked for it in writing, it was either denied or they got something different. And it happens. I understand. I understand that it happens. It raises a concern, a little bit of a red flag for me, because I guess my question is, are we giving ourselves the luxury of saying whatever we want by phone? And hopefully we're giving good advice, right? But not willing to stand by it when somebody says, hey, can you just confirm that?
I mean, we would stand by it if that was our actual determination. We do not try to provide advice unless it's verbally, unless it's a clear-cut situation. So, but again, mistakes are made. Other attorneys are involved. I can't speak for what's been told.
Is there a policy on providing phone advice for conflicts of interest questions as to particular circumstances?
We try very hard to only provide advice in those clear-cut circumstances.
But I mean, if I call up and say, I have a house, there's a project, I want to vote, that versus which regulation do I look to because I have property?
We can provide advice if it's pretty clear-cut. Previously, we had the clear-cut 500-foot rule. If somebody called up and were within 500, we could clearly say, no, you should not participate. If they are over 500, prior to the change of the 500-foot rule, we probably would advise, yes, as long as you only have a house and you're more than 500 feet away, you would be allowed to participate. That was the previous rules. Going to this it's not that it's a new standard, it's the statutory standard. The reasonable standard is pulled from the statute. The statute said, is there a reasonably foreseeable material effect? So it's not that we created a new standard, it's that we went back to something more consistent with the statute. Yeah. Now because that can be a more difficult determination, it's less likely that you're going to get phone advice in certain circumstances, but it may be more likely that but in certain circumstances, it may be more likely. For instance, somebody within 500 feet who has a very minor project next to them, previously you would have been absolutely disqualified. At this point, if it's a small enough project, it can be a pretty clear-cut answer, yes, you're allowed to participate. say it's 100, somebody's remodeling a house and adding 100 square feet, 400 feet from your property, we will issue a verbal advice or an email advice in those kind of circumstances.
So that was my question, right? I mean, I understand, I appreciate the standard that, and I appreciate you articulating it, and that's all very helpful. But my question wasn't about the standard. My question was, do we have a practice of giving advice by phone and then declining to confirm it in an email?
We will confirm it in an email if requested at the time of the verbal communication. Yeah. We
But
don't
he's
just,
saying that we didn't do that.
He's saying that he called back and spoke to somebody else who then didn't provide him the same answer.
That's not what he's saying.
But the answer is, if someone calls, asks for phone advice, we give it, and they say, can you confirm that in writing? That policy is to confirm it in writing,
Yes, we can confirm that in writing.
if requested. Yeah.
If we think there's enough there to confirm in writing. I mean, sometimes it's just general, we're providing general advice, and we're not going to provide a long primer on all the potential rules that may apply. So those are the types of things that if we provide very general assistance, we might say, you know, we're speaking to you in such a general matter, we're not going to be able to provide you some sort of like direct, quick
And if you want
confirmation
that,
of this general advice.
but if they wanted that, then you would advise them to do what? Write in
Write in with more specific facts.
to give it an advice
To
letter.
provide, for an advice that are correct.
So it's really the phone, and I think we really should pull back on the phone, but I know I get a lot of grief from that because of some of these issues, and I think the phone should be very technical advice because of all the potential problems and what the he said, she said, because we're just trying to be helpful, but someone's going to hear what they want to hear or just misunderstand what the answer is. And then we have the email advice, which is when we direct people to be a little bit more specific because they want it in writing, but it's not going to provide immunity. I'm just asking, right? Is that
Right, that's correct.
And then the third level is you want immunity or you want this flushed out so you can rely on this. Go ahead and request written letter.
Right.
Okay.
I have a record-keeping request.
Commissioner Hatch,
Yes, when we give,
you guys speak into the mic, please.
maybe that's why we didn't get recognized earlier. When we give oral advice, do we document that? And to what extent? So if somebody calls back and says, you know, that advice you gave me, I'd really like it in writing or an email confirmation or something, do we have anything to look at to see what, if anything, we'd given?
Sometimes we have the email confirmations and sometimes we do not.
Well, I mean, I'm assuming in this case that there was no request for an email confirmation at the time that they asked for the phone advice.
We generally do not. It depends on, I'll speak for the legal attorney.
You couldn't go back to the
I can
record
speak for
and
the
say,
legal
oh, yeah,
attorneys.
on December 5th, he called and we told him this.
The legal division, we do not keep like a written call log of the calls and responses.
I see.
That's scary.
Okay, then, could you, I know you touched on this, but it didn't sink in. Why is it that we ended up going from like a specific distance requirement to this more weighing apparatus where we weigh multiple factors? Was it a statutory requirement that we change it, or did we just, I mean, what changed that made us decide to change the way we do this?
Well, it started in 2013 under a prior administration, and it's just the direction of the commission was going back to a more statutory basis for the regulations and trying to, it was an attempt to clarify, it was an attempt to solve other issues. I mean, there's pros and cons between the bright line rules and the reasonable foreseeable rules.
Okay.
So
So this
you won't
was
find
an
a unanimous.
external influence, then this was a prior commission.
This was a prior commission.
Okay. Then we could go another way. Have we ever thought about doing like a safe harbor provisions that could be relied on that are fairly definitive?
I mean, I think that's what we had. I can say there's pros and cons of both. You won't find a unanimous consensus on which approach is better. You'll find a lot of support for bright line rules, but at the same time, I did do some extensive outreach to stakeholders about a year ago in regards to, the attitude or need for going back into the conflict of interest rules. and pretty unanimously was the direction was the regulated community wants some continuity in the rules at this point. So there's that balance as well. I mean, but again, that's kind of the direction of the commission, bright line versus the reasonable standards.
Yeah. I've only been reading these things every month for about 8 or 9 months now, but my, unwashed view of it is that we've put ourselves in a box here where we just have very labor intensive, on our part, requests to fill for these advice letters because our rules are vague in that term. So each one has to be carefully weighed, and then results would vary based upon the multiple inputs to that. Whereas something that's reasonably bright, a bright line guide, even if it's like just a safe harbor where if you're closer to the edge, you can ask for that weighing measurement. But if it's, the higher bright line rule, then you can rest assured that you're okay. It seems to me like we've put ourselves in an awful box with these advice letters. And I know it's not exactly on topic, although it was requested from him that the commission consider bright line rules on distance and so on. Because, it's hard for the elected official at the local level to know where the line is under our current application. So that pushes them to endlessly write us, requests for opinions or, advice on whether or not they can go ahead and vote on something. And it's probably backing up their agendas as well, because if they don't have sufficient votes to take action on things, then they have to delay them while they're waiting for us to, do our weighing machine operation. And it just kind of begs maybe do some third course where you have a set of bright line safe harbors that maybe not quite as tight as the old ones where it was, if it's here, it's okay, period. And here you could say, well, if it's like, let's say your old rule would have been 500 feet. You say, okay, well, 600 feet if you're within 600 feet, you're in our safe harbor and you don't have to think about all these other things. We'll just, pop them out.
You're actually arguing for an approach that was the initial approach before the bright lines, which was a dual approach. You had a safe harbor area where it was pretty much okay. Mm-hmm. You had a second area where you need to see, there's a more case-by-case determination, and the third area where it would be more than likely you're allowed to participate. Right. Again, there's just different ways of doing it over the years, and pros and cons to each.
Right, but you're stuck with all this work.
I can't deny that letters are a little more labor-intensive at this point.
Before that, you're stretched kind of thin over at legal. And so I'm just maybe asking that you might think about giving us some reasoned input on how we might, again, change our process that would facilitate your workload and also provide clear guidance for these local government officials that have to deal with this stuff.
Commissioner Hatch, I agree, and that is why about a year ago, when Brian and I were talking about the impact of the changes from 2013, how they're working, are there any areas that we think would improve it, he started by reaching out to the regulated community to say, would you like to reopen this? And I think, again, the pushback is this is so new and it's been a moving target, because even the way the changes to conflicts were implemented was a very strange rolling system. And I think you've heard enforcement talk to this. Like any given month, there's a different set of regulations that apply to you, on that day, literally. It's how many different packages of conflicts are there?
16.
16 different packages of what applies to you based on the period of time because of the way it was rolled out. So and you can speak to this, Brian, because you talked to the different people who live by this, the fairly overwhelming consensus was, can you give us more time to live with it in one set way before you open it back up again? But I do agree that we should open it back up again at some point. I think it's, when have we lived with it long enough to understand the full scope of potential problems, and do we even have a proposed solution that would not just bring us right back to where we were before? I mean, it could just be this rotating issue.
I would invite a staff memo from legal to give us, what you think would be a better way to do this after some considered thought, that we can then cogitate on and decide whether we institute a new rulemaking.
But in which,
And incur the wrath of the the regulated community.
so, yeah, and would we limit that issue, or would you like Brian to look particularly at, because again, the issue on this is even more complex because it's not just the 500 property rule, it's the business interest.
Right, there's multiple thresholds and materiality thresholds that were removed. There's business thresholds, there's personal financial effects. For every type of economic interest that's potential, there was previous more bright line materiality standards. So I guess the direction would be, do we want complete comprehensive overhaul? Do we want
Biggest problem
are there
areas
that we want to just try to focus on the 500-foot rule?
Can I just ask a question about the 16, because I think that'll inform kind of our thought on this issue. Are there the 16 standards because things were being rolled out little by little, but eventually we're going to catch up and there's going to be one standard because just because of the statute of limitations, we're not going to go back to that standard?
We're down to 16 now. So our statute of limitations is 5 years. And so the packets were, that's exactly what happened, was every commission meeting that something was adopted, then it went into effect either as an urgency or as a regular 30-day. And so it was a rolling target as to, so if you get a complaint and the complaint has 3 different dates for decisions, you could be 3 different packets of conflict of interest regulations. And so I think we're down to 16 now.
But as I get that, and my heart bleeds for you, but as to those 16, when do they horizon out? I mean, when are we done with the 16 and be left on?
It started in 2013, so it was the pre-2013, and as we get through 2018, we'll get rid of quite a few packets this year. But the majority of them, I think, fell in 2014.
We finalized the entire thing in mid-2015.
Yeah, so most of the activity happened in 14. So it's going to be a while.
And the reason I ask is because I wonder maybe we wait until we get to 1, right? And then we revisit, because otherwise, are we going to be revisiting 16 packets?
It'll be May 2020.
May 2020.
No, we wouldn't have to go back and revisit them all. We would just start with where we're at, but we would be starting the clock again if changes. I do think there's a legitimate point to timing on this, but I don't think that precludes us from starting the discussion that Commissioner Hatch requested.
And by the way, I would leave it to your discretion to recommend whether you focus on a particular problem area or whether you want to tackle the whole thing. I don't want to tell you what to say. I want you guys to think about how this is affecting your operation and what could be done to make it make more sense for both the public as well as us.
I just want to add into the mix of the discussion on the advice and leaving people hanging or what. I mean, other than requesting a written letter, again, we know that it doesn't provide immunity. And so short of that, the telephone or the email, I'm just curious, what is your understanding of how active county or city council is in providing advice to their very own members? Because it's kind of like our discussion earlier, going to our own legal counsel. Now, granted, it's not going to provide them immunity, but it's probably going to, if they get advice from their own city council or county council, I don't know who wants to answer this. I'm assuming it's going to be pretty strong and perhaps preclude us, or at least from going after enforcement.
It's severely mitigating. Unless they completely misrepresented to their city attorney or something, it's generally not something we want to pursue at an ALJ.
Sorry, yeah. And Brian, what's your understanding? Do you talk with the city and county council to encourage them to be more actively involved? Do they just say, kick it to us? What's their thought?
I think the approach differs between each city. I think some city attorneys kick all of them to us, and some city attorneys are much more active. And then at the same time, it comes down to how much the official listens to the city attorney. A lot of the time, a lot of our requests for advice are officials that got the wrong answer from the city attorney, so they're kind of coming for a second chance.
The wrong answer being not the one to want.
So it's hard. I mean, so it's hard to really assess how effective the advice through the city attorneys are. It really comes down to
Not so much effective, just more involved. Because to me, as far as our workload and their direct relationship, and especially as far as the phone and the email goes, since it's not providing immunity anyhow, I mean, I'm just not clear why that's not coming more from their direct legal counsel. But I don't know if you can answer that.
You know, we've had different approaches with the emails over the year. I mean, over the years, when it's gone from hardly ever providing advice through emails or phone when it comes to any kind of questions of conflict of interest, to trying to be more customer friendly and providing advice where we can. So,
Yeah.
I mean, it's all just a balance, and we try to take our lead from however the commission wants from us as far as either being responsive and quick and good customer service, and it's very appreciated when they can call us and say, we have a meeting this afternoon at this Tuesday, we have a meeting this afternoon at 5. Is this something we have a problem on? The old approach would have been, sit out, because until you have a chance to talk to seek formal advice, you need to sit out. Now, like I said, if it's more clear cut, we will try to, but I mean, that was essentially the direction that I've received over the years and the direction we were heading. So, I mean, but again, that comes down to whatever direction we receive as far as responsiveness versus accuracy and thoroughness, I suppose.
Well, I mean, again, I know that we
Shouldn't have said that.
regularly receive positive response from our phone advice. That's one of the things, if you ever go to any conference, city, League of Cities or what, they all love the fact that they can pick up a phone and actually call us and get an answer. So I understand that. I guess I would lean towards more cautious, at least in anything that becomes difficult, like conflicts, but it sounds like you guys already do that and have that balancing. Commissioner?
Yeah, I look forward to the day when I know enough about what's going on to be able to save myself from my save. But for my part, what I think I'm hearing here is a staff that is struggling with a very difficult task. There's a lot to be said, perhaps, for clear lines, clear, bright lines. It's binary, plus, minus, 1, 0. But very often fairness is lost in that kind of, a cookie cutter approach. What you're struggling with, what you should be struggling with, and if you approach your responsibilities dutifully and ethically, you should struggle with this, and I sense that you genuinely are, is these various factors that you have to take into consideration. Ultimately, trying to figure out what is the right answer here. And it's not readily apparent as a bright line, cookie cutter approach might lend itself to. And I just want to, for my own part, suggest that I appreciate what I gather is the work that you put into making these types of determinations. And I don't know enough about this to say anything other than my sense is that you are doing your best to stay in keeping with and in furtherance of the act in the best interest of everybody involved, including the people that you are, quote unquote, investigating. And so just remember that when I come down on you in the future. But I think I feel empathy for what I think you're having to deal with. Yeah.
Wait till you read your first conflict case.
Any other questions or comments from the commissioners? And I don't know if
I would like to
Commissioner Hayward?
For what it's worth. I think the notion that our little commission can be the mother may I for every potential financial conflict of interest of every state, local, and sub-local official in this state is certifiably nuts. And that's where we are. And that's not your fault. And, there's so many different ways that we can be gamed. People can, file complaints, understanding a person can't get advice while there's an active complaint open, which means they have to recuse, which means there's not that vote for something that this person doesn't like, yada, 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 and on and on. And you've seen all that, and you know what I mean probably better than me. So I don't think there are good answers. I think there's the binary, which is efficient, quick, certain, but potentially unfair. And then there is the reasonable standard, which takes a lot of work, a lot of time, and I don't know that there's a good reason for picking one over the other, except to the extent that we are trying to do this for a very large state, and it's kind of an impossible task. And maybe the efficiency arguments are important simply so that the wheels of government can keep turning. I don't know. I'm not saying that that's necessarily after we think about this some more and talk about this some more where I'd be, but I think given the ridiculousness of the situation, maybe bright lines are the best we can do to be reasonable to us. Anyway, that's all.
Commissioner O'Darrow?
I agree. I think that we need to look at this, and the appropriate time we can figure that out. But I want to go back to the specifics of this case. And I want to ask why exoneration is not an option.
Exoneration from enforcement?
Why we can't write a letter saying insufficient facts to support the allegation, and therefore no charge will come, we're done. Which is basically what he's asking, right? He's saying, thanks, I appreciate the fact that you closed the case. I appreciate the fact that there is no penalty. I appreciate all of that. Thanks very much. But here's the thing.
I missed the appreciation part in that letter, but okay, I'll take your word for it.
Again, I am grateful the case has ended. So, I mean,
Okay.
Okay.
All right.
In any event, we appreciate that.
Right.
But why is it that we can't say something more than closing the case? I mean, if I were charged with some crime, and it was investigated, and it was a he said, she said, no witnesses, no documents, and the investigator had no reason to disbelieve me any more than the other person saying the opposite, right? And so that's kind of the inconclusive situation, right? I would like for somebody to say, and therefore, you are not guilty.
Sure.
And I feel that the language in the letter, and it's the concern that he raises, is like, you're leaving me hanging. There's nothing that clears me here. Why can't we write a letter that says to the effect of, maybe we don't have to say not guilty because that's not the standard, but something that clears him from this. Why can't we do that?
Well, this is a no action closure, so it doesn't say you violated the act.
Right.
And that's what I feel is appropriate in this case. When you do these reasonable person tests and you go through all of these factors and it's 50-50 and you don't have the resources to go to an ALJ to prosecute a case, even though you have some factors that support prosecution, you can't say you're exonerated. You can say, I have found I am not taking any action in this case. Because when you say no violation, you're affirming that everything that you found is conclusively no violation. What I am saying is that we are closing this and we are not finding a violation in the case. Similar wording, different impact. So the reason that it's not an exoneration letter is because back in the day, we used to do no violation letters, and long time ago. But they were no violation letters even for de minimis violations, because they were de minimis and we weren't going to prosecute them. The appropriate title for these letters is no action, which is what enforcement is doing. We are taking no action and we found no violations.
And we found no violations, or is it something else you really meant to say?
We have not
Sufficient evidence?
have sufficient evidence in order to prosecute this case.
But in this case, Ms. West, it does seem, I guess it's the second part of the sentence that I'm wondering about, and how that played into your decision process, because it says, please note, however, this letter is not an exoneration. This is interesting. And you may wish to request advice before casting any related votes in the future. I mean, again, we're not calling this one, and we're not going to pursue it for various reasons that you list in the paragraph before: time, expense, money, changing law, all of the above, possible advice given, whatever. But before you do the same thing in the same context again, go back to legal and get your immunity.
Right, because our understanding during this whole case was that was the goal, that he wanted to get advice from the legal department to move forward, and that is what the letter's purpose was. We are closing this case. We are closing it without action. We will no longer pursue it. Please go get the advice that you wanted.
But it says, but before you do X, go get advice, which to me has a different tone. I think a reasonable person could interpret that to mean, we're not pursuing this, but by the way, don't do anything, which implies that if he were to vote, it would be wrong.
We're deferring to the legal division. That was what the sentence was meant to imply or infer or any of those I words, but it was meant to say, go get advice. You say you want to get advice, go get advice. This
And
is
we know
not
he's quite capable
a
of getting
determination that we are going to make.
He has one that just went out and one currently in the process.
So he's back with advice.
Right.
Okay.
Well, they can't hardly do their job at all without seeking advice after advice after advice, because they have all these geographic-related decisions they have to make.
Yeah. I just want you to be picked up.
Okay,
Otherwise
thank
you. You can't get heard. And a lot of times
Be on
you're...
the record. Yeah, big, long silence.
Yeah, exactly. Okay, and I'm just because we received, in addition to Mr. Lukin's letter, 2 public comment letters on this matter, I will ask if there's any public comment or anyone in the public who wishes to speak on this.
Chair Remke, Commissioners, first I'd like to thank you for reviewing my letter. I'm Eric Lukin, council member in the City of Novato. I also want to thank you for placing this matter on today's agenda and the discussion that is ensuing. In the 6 years that I've been an elected council member in the City of Novato, this is my first time attending one of your commission meetings, but I felt it was important for me to come and share some of the feedback and the experience that I had from this last case. In my time on the council, my involvement with the FPPC has historically been limited to filing my Form 700 every year, completing my ethics training every other year, and reaching out to the advice department for occasional conflict of interest questions. For nearly the past 2 years, though, I've spent a significant amount of time awaiting resolution on 2 conflict of interest complaints filed against me following a city council vote back in January of 2016. Based on my experience, I'd just like to share some feedback. I provided you with a lot of detail in my letter, and I think I could sum it up in just 4 main points. The first one, number 1, to please consider moving back to a set distance radius for conflict of interest matters. I believe that my situation shows that there is a lack of clarity on real property, material financial interests, and it's even more unclear when dealing with rental property where business material interests are introduced. Under the old 500-foot rule, it was crystal clear for myself, my colleagues, city staff, and city attorneys. Most cities and towns publish their council agendas 5 calendar days in advance, and that's usually over a weekend. But the formal advice requires 21 business days to weigh in on a conflict of interest matters. Given the lead time needed and the lack of a defined radius, I'm now having to request formal written advice from the FPPC on hypothetical projects and decisions up to a half-mile away from real property interests. I don't know that that's really in the best interest of efficiency and time. Number 2, if the rules can't be amended, the advice and the enforcement divisions need to have their staffing increased so that they can provide time-sensitive decisions sooner and more quickly resolve complaints. Number 3, I believe that a pending complaint should never result in a council member being refused advice on what I call unrelated projects. On 2 occasions while I was waiting for my case to be resolved over a span of 22 months, I asked for advice on 2 different projects which were unrelated to the complaints that had been filed against me, and both times the advice was denied because the subject property was the same, even though the project was in a different location. This left me and the city in a bad situation and potentially cost the city an economic development opportunity since I could not participate with the benefit of guidance. And number 4, while I am glad and I am appreciative that this case has been resolved and that it was eventually resolved with a closure letter, there is still some confusion on this matter, as you can tell by the comment letters that you received on this item today. The letter specifically stated it was not a letter of exoneration and that the information in the case will be retained and may be considered. I was not offered any administrative due process to challenge the finding. I believe that this is unfair and potentially unconstitutional. The closure letter was also sent to both of the sworn complainants since the letter states it is not a letter of exoneration, the interpretation is still in the eye of the beholder. I think the letter is inconsistent with prior FPPC practice where warning letters allow for due process and closure letters say that the law wasn't violated, so it's somewhere in between. I couldn't find any other letters like the one that I received on the FPPC website. Glad to share that feedback with you. I want to thank you for hearing this matter and the discussion that ensues. I certainly hope that I can be a resource in any way to help craft clearer regulations moving forward that will make it easier for local elected officials like myself to do our job and to participate in the votes that we need to. With regards to my specific closure letter, I'm asking that you rescind the letter that was sent and either provide me with a hearing or a letter that says I did not violate the law. Thank you.
Okay, any further public comment on this matter? Okay, thank you. Thank you, Mr. Lucan. All right, so the next matter is item 28, which are our staff reports. Any questions or comments from the commissioners?
Wait. Can we make a motion on this matter?
No.
Why not?
There is no, it's not an action item. There is no.
What? How is it not an action item?
What would you describe the action as it has been listed here?
A response to Mr. Lucan's request that we rescind the letter and issue a letter that he didn't violate the law. I thought that was a part of the, hold on. I think that is in his letter. And then he just reiterated it.
I don't believe, and if nothing else, I would propose that we put this over and put that as the action. I don't even know if we have in our regulations, and maybe Ms. West or someone could tell me if we have the authority to set aside a closure letter. And I don't even know what that would be. And again, we've come up against this before, and I have a certain concern. So if we're going to, if the request is to take actual action on this, we'll have to put this over with a statement of what the requested action from the commission is, because it is not listed as an action item. And then we could perhaps pursue the legal authority for the commission to set aside a closure letter, to reissue a closure letter.
Point of order.
Yes.
I was told by the chair at a previous meeting that all of these items are action items, including the reports.
Well, then I
Now,
must
why
have
is it that this-
misspoke.
We don't say on any of these items action from item 3 on down. None of them tell you whether it's an action item or not. And I believe that you can't distinguish and call this an item that's not subject to action. My point of order is that a request to make a motion on this item is well taken.
I guess there are two questions right now, whether we can take action on this time, and then I would insert the additional question whether we have the authority to take what I'm understanding the proposed action to be.
My point of order
Right, I've
for
added
now,
to it.
not
Thank you.
for next month.
Yeah, I don't think we've necessarily listed it as action or discussion. We do say it's in the last sentence, It's placed on, well, we do. We say it's placed on the agenda for discussion and that Mr. Lucan be notified. So we have put it in the category of discussion item only. And I think my recommendation would be then to bring it back next meeting and so we can take action on it.
Again, press my point of order. My point of order is that this is in fact an action item just as much as all of the previous items ahead of it on this agenda are. And that I would like a ruling from the chair, and if I don't agree with that, I want to press for a challenge of the chair's ruling.
Right. I say it is a non-action item. As listed, it clearly says is placed on the agenda for discussion.
Okay, I challenge the chair's ruling and would ask for a vote on that, as is prescribed in Robert's Rules of Order.
Correct. Is there a second on the challenge of my ruling?
Does it require a second?
Okay. Does require a second. Okay, please take the roll.
Commissioner Darrow?
I'm voting with the challenge. I don't know if that's a yes or a no. I'm voting with the challenge.
Commissioner Cardenas? Commissioner Hatch?
Yes.
Commissioner Hayward?
I'm still reading the agenda. I'm still reading the agenda because I think that's important.
Can I point out something? It says the commission may take action on any item listed on this agenda. The agenda says
Right, there's
that
a motion pending, and we're waiting for a vote. Thank you.
Yeah, I'm going to have to go with the challenge.
Chair Remke?
No.
Motion passes.
Okay, so what is the motion, and who made the motion?
No one's made it yet.
What's the motion?
We were trying to make it. I move, and I have to kind of think this through, and I'm happy to have a collaborative effort on this motion, but I do move that we rescind the closure letter. Either rescinded or, let me take that back. I withdraw that. I move that we revise the closure letter to include language that there is insufficient evidence to support the allegation. At the very, I think I would say that there's insufficient evidence to support the allegation as made in the complaint, and however you want to identify the complaint.
A second.
I don't know if this is a point of order or a point of information. Do you have authority for our ability to direct enforcement to redraft their closure letters? I'm just concerned about crossing the line of prosecutorial discretion. So I'm just wondering where the authority in the regulations or the act come from this motion.
Are you asking me?
Yes.
I don't have it. Do you have the opposite?
I know it doesn't exist. There's nowhere that it says this is appropriate action. So that's why I'm asking, where is the authority?
Well, if there's, I don't have anything that says it's not.
Well, I do have precedent, perhaps, on a case, I think it was called the Sears case, where we asked that they change it from a proposed fine to a
Warning letter. Warning letter.
a warning letter, yes.
Which, again, I did raise concerns, but at least there we were voting on the proposed fine, rejecting it with direction. So here, again, it's because it wasn't presented
Maybe
as
talking
approval.
semantics here.
Well, I think either something's presented from enforcement to us for a vote on an enforcement action that we approve or deny. Personally, I don't know the authority, and I'm unaware of the authority to direct enforcement to redraft a closure letter, as it is not before us. The case is closed.
But we have a closure letter that's in dispute as to its impact. I would ask, Galena, what of the other request that was made relative to giving him his day in court over whether or not he had violated the act?
Well, since we found no violation, there was no day in court. We did not pursue the violation, and we allowed him to receive advice. So if you're not doing a warning letter or a fine or proposing anything to an ALJ, making a probable cause or an accusation, there is no allegation pending against Mr. Lucan.
Right, but Mr. Lucan is in a position of having kind of a black cloud hanging over him over this, and he is in the political realm, which means that someone can use this against him at a future date. And it's kind of sounds like he's guilty the way it reads, and so I appreciate Mr. Darrow's efforts to try and ameliorate this in some way, and I'm not getting the sense that that's going to be easily digested.
May I?
Yes, Commissioner?
Maybe I'm missing something. Maybe I'm missing a lot. And whatever I'm missing, it appears to be material to at least a couple of members of this board. But if I'm not mistaken, this is an elected official. This is a politician.
Right.
A professional. Black cloud, are we in the business of removing shades of gray or even blackness from individuals? If a reasonable person, or maybe even a somewhat unreasonable person, can read this on its face, I suggest, not at all malevolent, rather vanilla, a letter, as being a black cloud, he's in the wrong business, and I don't think it's our business to be concerned about that in the absence of a real castigating indictment statement in the letter, which is beyond my cognizance. I just don't think that's our role. And what the hell do we have staff for if they're going to spend all of this time and we're going to substitute our judgment? Now, the two of you have been here longer, so maybe you have, the expertise and whatever it takes to substitute your judgment for all of theirs. Mm-hmm. But in the 24 hours or so since I've been sworn in, I don't have what it takes to substitute my judgment for theirs, and I won't.
Okay.
Any other comments or questions from the commissioners on the pending motion?
I would just say, I think once a matter is closed and gone, it is in fact closed and gone. I do wonder at his representations that this was an unusual letter. I can't imagine that you came up with wording just for him, but maybe you did. In any case, I do think that the sort of you're okay but you're not okay tone toward the end of this letter on page 3 is a little, I don't know. We might think about that in the future, that's all. But for now, what's done is done.
Any further comments before we take roll? Any further comments before we take roll? Take roll, please.
Commissioner Adaro?
Yes.
Commissioner Cardenas?
What in the world is the motion again?
The motion is to modify this, to instruct Enforcement Division to modify their closure letter to include language that states, what did it state, Commissioner Odero?
It's insufficient evidence to support the allegations as made in complaint.
The motion is to modify the letter at the direction of the commission.
I'm supposed to state on the record that I find insufficient evidence for staff's. No, I vote no.
Commissioner Hatch?
Aye.
Commissioner Hayward?
No.
Chair Rumke?
No.
Motion fails.
Sorry? I had an alternative thought, which I could convert into a motion that enforcement staff write a further letter clarifying that this letter didn't constitute, did not constitute a conviction, and that it was, there was not sufficient evidence to do so, or words to that effect.
So you're making another motion?
Yes, ma'am.
Is there a second?
I'll second it.
Commissioner Darrow?
Yes.
Commissioner Cardenas?
No.
Commissioner Hatch?
Aye.
Commissioner Hayward?
No.
Chair Remke?
No.
Motion fails.
All right, so now moving on to item 28, the executive staff reports. Any questions or comments from the commissioners?
I do.
Commissioner Odero.
So on the enforcement report, which, give me a second so I can bring it up. I appreciate all the data. I think it's very helpful and it's nice to have, and it gives us a nice history. I have a question about the referrals from the Secretary of State. So I think we're going to revisit an old subject you may recall.
I do.
And this is the situation of where there's an annual fee of $50, and then there's a fine of $150 if the annual fee isn't paid. And then if that $200 isn't paid, then it gets, as I understand it from our last conversation months ago, it comes to us for enforcement, right?
Yes.
Okay. And we had a lengthy discussion in one particular case where there was like, I don't remember the exact numbers, but where I think it was like $600 multiplied into thousands of dollars.
There's a default, yes.
Yeah. And so since then, we haven't seen any cases like that. And I think in an earlier meeting, you mentioned that, yeah, because I'm not going to bring any.
I did say something to that effect, yes.
Well, it was clarified, right?
Until it was clarified.
Yeah, fair enough. But we never circled back on that. And the other thing I recall from the conversation that we had that day was that we appear to have some kind of an agreement, an obligation to the Secretary of State that we are going to do enforcement on those. And I think Chair Remke at that point said, well, fine, then we'll just tell the Secretary of State we're not going to do it anymore, which was a knee-jerk reaction that we agreed would
I would
not vote.
prefer if you did not restate what I said
Well, the
perhaps
record,
6 to
yeah, that's fair
12
enough.
months ago.
No, that's okay. The record will show what it was. I mean, it is what it is. But the point is, we never revisited it, and if we have an obligation to the Secretary of State, and it seems that we do, I think that we need to figure out what we're going to do, because I also have questions about, we have... you have a list of the number of cases from the various years. Let me see if I can find that. Of these types of cases. Oh, yeah, and here it is. And how many are remaining? And so in 2015, we received 24, almost 2,500 annual fees, referrals for the year 2013. And of those, 29 remain pending. And then for the year 2014, there were almost 1,800, of which 42 remain pending. And then it says we're receiving 2015, 16, and 17 referrals periodically. So my question is, are we enforcing these, and we, the commission, is just not seeing this anymore? Have we stopped enforcing? What are we doing with the ones that, can you kind of bring us up to date on what we're doing here?
Sure. Just want to reassure you, there's no backroom enforcement of this, not going through the commission. But I'm actually going to defer to Erin Pett, the executive director, because she's been working on this since it was pending before the commission.
Sure.
Yes, I'm happy to bring you guys up to speed. So since that discussion, which I'm now forgetting what month it was, maybe April or May of last year, we have been attempting to seek clarification both from the Secretary of State's office and or alternatively the legislature in terms of what was the legislative intent at the time the bill was enacted, obviously, in terms of whether it's the $50 plus the $150 and that's it, or is it the $50 and the $150 as a late fee, to use the term, and then we also would have an enforcement penalty on top of that. I can tell you that I personally have met with both committee consultants in both the Senate and the Assembly and at the Secretary of State's office, so there is some effort to seek clarification. And in the meantime, as it says in the memo, the Secretary of State's office is referring over some of the cases, so they are being administratively processed up until the point where we can't act until we have clarification. One of the things that's talked about in this memo, I believe, and I'm here, like it says there in December, we administratively terminated 29 committees. That's the regulation that allows essentially non-active committees to be closed so that the clerks and ourselves don't waste a lot of time trying to go after people that they just forgot to file the last statement or something. Those are definitely being processed. That's ongoing. In terms of when we'll have a resolution on the question, I don't know, but I can assure you we're doing our best as staff to try to get some sort of direction from, I hope, potentially the legislature, if that's something that they're willing to give us further direction. One further complication I would just add is that the author of the bill is currently in prison, and so in theory, there's opportunity in a different situation to ask the author of the bill what he intended, but that's not available to us. So that's where we're at.
Yeah, although it's just like what we went through in AB 249, I think it was, where we got one of the authors of the bill saying, here's what I intended, and we all agreed that that was kind of
correct.
It's not
determinative of legislative intent entirely. I mean, and there is case law that says an individual member's viewpoint. However, it might at least, in theory, could shed some sort of light on what
Or
was
he
intended.
or someone else then would be more likely to carry legislation
To clean it
draft
up.
more.
Correct.
Now I just don't think there's much interest is part of the problem.
Correct. That appears to be the case.
So in the meantime, we have all this stuff that's kind of pending, subject to an agreement that we're not fulfilling. And I'm just wondering, Mr. Woodside, is there a way that the legal division can tell us the answer to this? At least, I get not binding.
I mean, we can bring it back in front of the commission with our recommendation, and I think that was the direction earlier on. It's just a matter of timing, when it's going to happen.
I mean, because if what we're doing is we're asking the Secretary of State to tell us what the legislative intent was,
No, that's not what I said. I said I went to the legislature. We were working with the Secretary of State's office because they also care about this and want to have some sort of resolution. So we've been talking to as many people as possible to figure out what are our possible options to move forward to get this resolved one way or the other. And I think, again, as staff, we would like clarification. We would like to move the cases. And so and just to be honest, we were also, we obviously had an absent commissioner, or a spot open, I should say. And so now we have a full complement on our committee. I didn't mean to imply that you were absent personally, but anyway, now we have a full complement on the commission, and that is also potentially a better option to bring forward basically a policy determination on how the commission sees this.
Have you explored whether or not this would be a subject of streamlined process?
Yes, it is in the streamline memo.
It currently is.
Correct.
It still is a problem.
Well, I think it's a legal question that Commissioner Hayward raised as to whether we have authority to both collect. So there's sort of three pots of money, to make it simple. There's the $50 everyone's supposed to pay annually. The legislation says if you fail to pay that, you pay up to $150 penalty, I believe it says. And then basically we would have our up to $5,000 per violation. So there's a legal question, I think, that was raised as to whether the sole remedies available are to make them pay the $50 plus the $150, and that's it, or do we have jurisdiction to make them pay the $50, the $150, and up to $5,000 for each calendar year they didn't pay the fee? And so I think so the streamline memo, as adopted by the commission, took the latter approach, that there's three pots of money. I think Commissioner Hayward, correct me if I'm mischaracterizing, but I think
And the statute.
and the statute, potentially. Anyway, so she asked the question, is it only the 50 and the 150? If that makes sense.
Yep. So it's at Secretary of State's for a $50 collection, and then they can tack on a $150 fine for not paying the $50. And if they still don't get it, they refer it to us for enforcement.
Correct.
And then we interpret that as staff and pursuant to the streamlined memo that we could seek enforcement penalties as well.
Correct.
It was raised that the final pot of money might be in question.
Yes.
So that's where we're at. So,
Does anybody sue us over this, or is this just timid?
no, just Commissioner Hayward.
And the statute. Just to remind everyone, since there seems to be a little bit of amnesia on this point, the statute says no fees for filing, except that there is this $50 annual fee that people have to pay that goes to fund CalAccess. It is constitutionally problematic to impose a filing fee unless you have it going to something that has a close nexus to filing, like CalAccess. And so you shouldn't read the statute in a way that brings up constitutional problems. That's a good statutory construction principle. Plus, the statute says no fees except we've carved out this little exception. And I just pointed out that the little exception is a little exception. It's not a little exception that then bounces over into our venue where the fees can go into the thousands and thousands. And people will say, well, that's not really a fee. That's an enforcement fine. And I don't see anything in the statute that supports that kind of parsing. And that's my point.
And I'm not even going to do a counter argument at this point. So the issue is it's still being worked out. I guess the question is, can we give staff another month or so to try to work it out with the powers that be for clarification? And if not, we come back with a legal memo with a recommendation to us.
Yes, that
makes sense.
Okay. Any other questions on the staff report? Okay, hearing none, it will be submitted. As for future agenda items, are there any new ones that are not already in the pipeline?
I have a couple.
Yes.
I don't know if it needs to be an agenda item, but I would really appreciate if you could send to me or circulate, and especially now with the new commissioner, the May 2015 Streamline memo. That would be the only thing I would ask. And then I would like for us to put on the next agenda the beginnings of a discussion for us to do a process review of enforcement so that we can review it, take a look at it, get public comment on what works, what doesn't work, what's helpful, what's not helpful, and then make some. I don't know if there's even anything that's written. I don't know that there's an enforcement manual, for example. So I know I'm familiar with the Department of Labor Standards Enforcement here in California has an enforcement manual. This is how we're going to enforce things. And it has some substantive rules, et cetera, and I'm not suggesting that we go into the substantive issues, but I would like a thorough review of our enforcement process with public comment and just kind of put that idea on the next agenda so that we can discuss how to go about doing that, and whether that is the creation of a committee like the governance committee that we created, or we do this without a committee and we do completely open and public comment without having a committee that makes a recommendation to the commission. So I would like that put on the agenda.
Okay. Any other items for future agendas that have not already been discussed? Okay, thank you. Motion to adjourn?
I'll move.
Commissioner Darrow?
Oh, did somebody second? Okay. Yes.
Commissioner Cardenas?
We're voting to adjourn?
Yeah.
Yes.
Commissioner Hatch?
Aye.
Commissioner Hayward?
Yes.
Chair Remke?
Yes.
Motion passes.
All right. Thank you.